Good afternoon, Ms. Bridgewater. How are you this afternoon?
Oh, great, Your Honor. How are you?
I'm the same, thank you.
Good. July the 15th.
Thank you very much. It's the SAP reset date.
It is, yes.
Okay. Courtroom two, as we wait for everyone to join us, would you like me to go ahead and make my announcement?
Yes, Judge, I'm gonna have to do, two different, um, I lost the word I was about to say, but two different
Right.
groups. Yeah, anyway, so.
Okay, I understand. Just let me know when the second group comes in so that I can make it for them, okay?
Will do.
Okay, thank you. Thank you so much. And I'll let these gentlemen sit down here that are coming in. Very good. Good afternoon, ladies and gentlemen. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. You have a right to remain silent. Anything that you say can be used against you. You have a right to have an attorney present at these proceedings. If you do not have a private attorney, we're providing you with the assistance of a public defender this afternoon if you choose to utilize their service. It's right before two. Let me wait till 2 o'clock and make sure everyone's on with us, and then we can proceed. Okay, it's right at 2 o'clock. Who do we have first?
You can start with position two, Mr. Ballard.
Good afternoon, Mr. Ballard. You have been charged in case 25 CR 003643Y with battery and simple battery. Who do we have on from, yes, Miss Jackson. Good afternoon. Is there a history?
Good afternoon. Yes, there are 40 cycles. The last arrest was March the 25th, 2025, out of Gwinnett County for a probation violation. It does appear to have open probation cases. One out of Fayette County for theft by shoplifting. That disposition date was June the 6th, 2019. And the term is for 9 years and 8 months. And there appears to be one out of Gwinnett County for theft by deception and identity theft fraud. That disposition date was June the 11th, 2021, and the term is for 10 years. And there's one out of Fulton County. That case number is 22 SC 185553 for aggravated assault and false imprisonment. And that disposition date was July the 3rd, 2023, and the term is for 9 years. It's an additional open probation case out of Fulton County. That case number is 24 SC 005622 for simple battery. That disposition date was June the 18th, 2025, and the term is for 12 months. Also, he appears to have outstanding holds. One out of Dallas, Georgia, for a probation violation. The date on that warrant is April the 1st, 2025. And one out of Fayetteville, Georgia, for a probation violation. The date on that warrant was March the 31st, 2025. He does have prior felony convictions and a sentence. One in 2019 out of Cobb County for theft by receiving stolen property. One in 2019 out of Fayette County for possession of controlled substance. One in 2018 out of Paulding County for 5 counts of financial or transaction card fraud. And he received first offender treatment in 2011 for burglary, and that case was sealed July the 6th, 2017. And there are misdemeanor convictions and sentences. One in 2019, he received a no contender sentence out of Henry County for driving without a valid license. And he received a no contender sentence in 2017 out of DeKalb County for criminal trespassing. And there was a conviction in 2017 for possession of marijuana less than an ounce. One in 2016 for simple battery and cruelty to children in the 3rd degree. And there was one in 2015 out of DeKalb County for theft by shoplifting, one in 2012 out of DeKalb County for theft by shoplifting, an additional one in 2012 for theft by shoplifting and simple battery. And he appears to meet the criteria for UJR level 3. Nothing in addition, Your Honor.
Thank you. Good afternoon, Ms. Falk.
Good afternoon, Your Honor. This is the case with Marcus Ballard. Is that correct?
Yes, position number 2.
Yes, Your Honor. This incident happened on June 27th, 2025 at 1428 Donnelly Avenue. The victim in this case, Miss Rayett Walker, was on that date reported to police that, that Miss Singleton ran into her home to seek safety from the defendant, Mr. Ballard. Mr. Ballard attempted to enter her home without permission and refused to leave when asked. Ms. Walker stated that the defendant threatened to call his girlfriend to fight her. She reported that shortly thereafter, Ms. Craig, who is a co-defendant in this case, Lena Craig, came to her door and initiated a physical altercation. During this fight, the defendant tripped her and punched her in the face. Ms. Walker did have bleeding from the mouth. They also talked to Mr. Singleton, who did, Lorraine Singleton, who did corroborate the accounts of Miss Walker that this individual came into her home without consent and then had his girlfriend fight her. A independent witness, Miss Tawana Brewster, also provided a statement saying she saw the Miss Craig approach Miss Walker aggressively and begin punching her. And at that point, the defendant jumped in and punched Miss Walker in the face during an altercation. So not only do we have statements from the victim, Miss Walker, we have corroborating statements from Mr. Singleton and a completely independent witness, Miss Brewster, who was not even present, who wasn't even a part of the interaction, who observed what happened and was also able to give a statement to police. Your Honor has heard the defendant's lengthy history of violence and several cases on which he is currently on active probation, both a 2023 and a 2024 SC case. For that reason, the state is asking for a $7,500 surety bond. The defendant also has holds out of Paulding and Fayette County. No further contact with Rayett Walker. Stay away from 1428 Donnelly Avenue Southwest. 3 days anger management and no alcohol, drugs, or weapons. We would like to sound at this time for Ms. Walker. If she is present, would like to speak. That's all for the state.
Ms. Walker, I see to address the court, I will need for you to activate your camera for me. Yes,
Hey,
ma'am.
hello. Hi, how
Yes,
are you doing?
yes, I'm doing fine. Good afternoon, Ms. Walker. If you can raise your right hand for me, please, ma'am.
Yes, sir.
Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down, Ms. Walker. What would you like to tell the court?
I just feel like y'all need to lock him up. I just don't think that is no reason for a person like that to be on the street or in a neighborhood like that in the first place. Just because of how he conducts himself and what he's done previously, just hearing all those charges, I don't even know this man from a can of paint. So the fact that he even punched me or all of this went on based off of me trying to protect somebody else is not acceptable at all for a human being to be on the street like that. It's not. My lip is still healing, actually. And I just feel like, for him to take it that excessively, I just feel like he needs to be locked back up for that. It's no reason why he would be back on the street.
Okay, thank you, Ms. Walker. We appreciate you being here this afternoon.
You're welcome.
Ms. Tucker, good afternoon.
Good afternoon, Your Honor. Mr. Ballard is a 31-year-old Atlanta native. He was able to provide me with the address that he's held for the last 20 years, that he has family members at as well. He's obtained his GED. However, he is not currently employed. He was incarcerated at Gwinnett County, and he, through Gwinnett County, was participating in a work release program. So he was participating in work through that. We have no objections to having no contact with Ms. Walker, as well as stay away from the incident location. However, we are requesting the lowest bond that the court will allow in this matter. The state just recommended a $7,500 surety bond. However, there was a bond previously set for Mr. Ballard at $2,500. So I'm not sure why the state is requesting more at this time. We are actually requesting a lower bond at this time on his behalf than the one that was previously set, as he has been incarcerated and doing work release. He does not currently have income coming in. So that's what we are requesting, the lowest bond that the court will allow.
And Your Honor, I do apologize. I did not realize on this case a bond had already been preset. I know that we are starting that policy beginning next week, but the state will agree to honor the existing bond.
Okay. Based on his history and the number of probation violations that currently in that he has 2 holes. It will be a $3,000 for the battery. It will be a $3,000 surety bond. For the simple battery, it will be a $2,000 surety bond. Makes for a total of a $5,000 surety bond. No further contact with Ms. Walker. Stay away from the Donald Lee Avenue address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Ballard.
Go to position 23, Ms. Moffitt.
Good afternoon, Ms. Moffitt. You have been charged in case 25 CR 003654G with a fray. Is there a history?
Judge, before we go any further, we might want to make sure that we have, this was a dual arrest. It is Worthen, Miss Worthen. Let me see what position she is.
Okay, so I see Ms. McLeod and Ms. McLean, Mr. McLean on. Thank you for letting us know, Mr. Sirocco. Whose client is Ms. Moffitt?
That's mine. She is mine, Your Honor.
Okay, and who's the other person, Mr. Sirocco?
It's Worthen, Your Honor. Good afternoon.
Good afternoon.
Position 32.
Thank you. And courtroom 2, do we have Worthen in the courtroom as well?
No, Judge. I can go get her if you want me to, but I just left her out because of the conflict.
I understand. We will come back. So we'll take care of, we'll be with Ms. Worthen soon, Ms. McLeod. Let's go forward with Ms. Moffitt at this time. Thank you, Mr. Sirocco. Yes, Ms. Jackson.
There are no prior arrests, Your Honor. She does appear to meet the criteria for UJ or through the jail. Nothing in addition.
Yes, Mr. Sirocco.
Thank you, Judge. This incident took place June 29th of this year at 1117 Lee Street in Atlanta. It's the Texaco gas station. Law enforcement observed 2 females fighting at the location. The officer had turned on the emergency lights and sirens to break up the large crowd that had gathered there and made contact with one of the women, Miss Isaiah Worthen, who explained that she and the defendant had previous problems regarding a guy and had been arguing on social media. The 2 met at Texaco and engaged in mutual combat. The defendant fought Miss Worthen, leaving scratches to her left side of her head and the right side of her lip. Miss Worthen sustained a scratch to the left side of her face and the right side of her mouth, while the defendant sustained a bite mark. There's no surveillance footage available to determine the primary aggressor. It sounds like this was mutual combat. Both parties were taken into custody. With no history here, the state's recommendation is a signature bond through pretrial services with a day of anger awareness, no further contact with Isaiah Worthen. Stay away from 1117 Lee Street in Atlanta, again, the Texaco, and no drugs, weapons, or alcohol while out on bond.
Thank you. Mr. McLean, if agreeable with you, it'll be $1,000 signature bond through the jail. No further contact with Ms. Worthen. Stay away from that Texaco, and no drugs, alcohol, weapons while out on bond. Does that suit you?
It does, Your Honor, no problem.
Okay, very good. Good luck to you, Ms. Moffitt.
Next is position 27, Ms. Thompson.
Judge, this case is actually, we're going to be null prosing this case.
Okay, very good. Ms. Thompson, your case is going to be dismissed. It's going to be null pros. Good luck to you, ma'am.
And I will send that over shortly.
Thank you.
Next is position 6, Mr. Dean.
Good afternoon, Mr. Dean. You have been charged in case 25 CR 003650G with loitering or prowling. Is there a history, Ms. Jackson?
Yes, Your Honor, I'm just pulling it now.
And Your Honor, while pretrial services is pulling that up, Tony Everett is the co-defendant with Mr. Dean. I'm not sure if he's in courtroom two. Courtroom two, I swear to God, I'm not trying to make it harder on you, but if he is present, if we could address him as well.
Sorry, I had missounded it. There are 21 cycles. Last arrest was November the 21st, 2021, with the City of Atlanta Police Department for possession of methamphetamine and giving false information to an officer and aggravated assault. Does appear to be on probation in Fulton County for possession of methamphetamine with the intent to distribute and entering an automobile. The case number is 22 SC 182662. That disposition date was September the 13th, 2023, and the term is for 8 years. Also, it appears to have an additional open probation case in Fulton County. That case number is 23 SC 186445 for aggravated assault and possession of a firearm by a convicted felon. That disposition date was September the 13th, 2023, and the term is for 8 years. There are prior felony convictions. One in 1992 for possession of controlled substance, one in 1987 for dangerous drugs, one in 1986 for robbery and theft by receiving stolen property. He does have a misdemeanor sentence and a conviction. He received a no low contendere sentence in 2019 for driving without a valid license, and there was a conviction in 2012 out of Douglas County for giving false information to an officer in simple battery, and he appears to meet the criteria for a UJR level 3. Nothing in addition.
And I take it that Mr. Everett's not with us. Is that right, courtroom 2?
Yes, Judge. Somebody just went to go get him.
Okay,
Okay.
thank you.
Your Honor, we're actually gonna have to conflict Mr. Everett out. That wasn't previously done.
Okay, so and Miss McLeod, is she, well, so this is Mr. Dean,
Mhm.
right? So Mr. Everett, Miss McLeod, are you with me? Okay, well, once Ms. McLeod gets back with us, and I'll ask if she can handle that case for us this afternoon. Let's proceed forward with Mr. Dean.
Yes, Your Honor. This incident happened on June 28th, 2025 at 2760 Deerwood Drive in Atlanta, Georgia. The victim contacted the police and stated that there was a burglary in progress. Miss Quenisha Jackson told police that she saw the defendants on surveillance camera peering into her open window inside of her yard, looking through an open window. This occurred at about 6:00 p.m. Officers responded to that location, saw that the defendant, who was initially identified only as Tony, had fled the scene on foot to a nearby wooded area just before the officer's arrival. Ms. Jackson provided a clear account of the events and showed the surveillance video capturing the defendant on her property without permission or legal justification. The police arrived before they could actually enter the home. Also, Ms. Jackson reported an exterior air conditioning unit had been tampered with during the incident. A witness, Willie Williams, was interviewed and stated and confirmed that he saw the defendants on the property at the time, which further corroborated their involvement. And he said that Mr. Samuel Binney stated to Mr. Williams he had seen some copper on the property and wanted to take it. That's another individual who was also at the scene, who was later, Mr. Vinny was then later identified, I believe, as Mr. Tony Everett. But they knew him as Samuel Vinny, it looks like. So Mr. Dean was present and it was verified by independent witnesses that he was on the scene. Currently, there is a $1,000 surety bond set on this case, preset by the magistrate court. And we're also asking for a stay away from 2752 Deerwood Drive in Atlanta, Georgia. No further contact with Quenisha Jackson, no alcohol, drugs, or weapons. That's all for the state.
Okay. If Ms. Quenisha Jackson is on the line and wishes to address the court, now is your opportunity. Does not appear so. Ms. Tucker?
Yes, Your Honor. Mr. Dean is a 56-year-old Atlanta native. He has completed his high school education. He is currently not employed due to a number of disabilities. So he is not able to work at this time. He's told me that he has a rod in his leg. He has kidney issues. So he is unable to work due to his disabilities. We have no objections to a stay away from the incident location, and we're requesting the lowest bond amount that the court will allow on Mr. Dean's behalf.
It will remain at $1,000 surety, no further contact with Ms. Jackson, stay away from the Deerwood Drive address, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Dean. Ms. McLeod, have you been able to speak with position number 10, Tony Everett?
No. I
Okay.
believe he discovered he was a conflict, but I can speak with him.
Okay, so can we get Mr. Everett to a phone so that Ms. McLeod can talk with him, please? Thank you.
Go to position 32, Ms. Worthing. Oh, well, sorry, never mind. That's Mr. Cloud's claim. We can go to position 15, Mr. Harper.
Okay. Good afternoon, Mr. Harper. You have been charged in case 25 CR 003669B with terroristic threats and acts and willful obstruction of law enforcement officers. Is there a history, Ms. Jackson?
There are 59 cycles. The last arrest was March the 10th, 2025 out of DeKalb County for battery and a charge associated with the CWAC. That case appeared to be still pending. He does appear to be on probation in Fulton County. The case number is 21 SC 1778384 for aggravated assault. That disposition date was April the 7th, 2021, and the term is for 9 years and 6 months. There appears to be an additional open probation case in Fulton County. That case number is 22 SC 183577 for aggravated stalking and aggravated assault. That disposition date was May the 2nd, 2023, and the term is for 3 years. And he does have prior felony convictions, one in 2013 out of Cobb County for terroristic threats and acts, one in 2010 for forgery, and one in 1999 out of South Carolina for threatening the life of a public official. And I apologize, I was out of order. There was one in 2007 out of Florida for grand theft and escape. And there are misdemeanor sentences and convictions. Received a nolo contendere sentence in 2021 out of Gwinnett County for simple battery. One in 2012 out of DeKalb County for simple assault. One in 2011 out of Gwinnett County for escape. One in 2010 out of Gwinnett County for simple battery. And there was one in 2005 out of Florida for battery. And he appears to meet the criteria for UJR level 3. Nothing in addition, Your Honor.
Thank you. Good afternoon, Mr. Nixon.
Good afternoon, Your Honor. This incident occurred on June 28th, 2025, while patrolling Martin North Avenue. Corporal Waiters was dispatched to respond to a report of an unknown male acting disorderly on train 293, who was armed with a knife, and the male exited the train at Martin North Avenue and began yelling and cursing at Martin Protective Specialist Littles, who was also on train 293 traveling southbound towards the North Avenue. The defendant had been arguing with another passenger while holding the blue knife and had been observed yelling at someone on the train at Midtown. And upon arrival, the officer encountered the defendant. He became increasingly argumentative and disorderly, and as Corporal continued his investigation, the defendant began digging through his backpack. This prompted him to place him in handcuffs, and while being detained, he resisted by clenching his fist in a fighting stance and yanking his arm away from him. And after securing him in handcuffs, he began yelling threats, repeatedly stating that he would kill and shoot the corporal while being escorted for processing. You've heard the extensive criminal history, Your Honor. I think I noted history out of South Carolina and as well as Florida, along with the 2023 FTA and probation revocation. With the criminal history and the facts of this case, Your Honor, the state is going to recommend $1,000 surety for terroristic threats, $1,500 surety for the obstruction, a stay away from all MARTA, no alcohol, drugs, or weapons, anger awareness, as well as MHET. And the state would ask that. It's actually all, nothing further from the state.
Thank you. Afternoon, Mr. Bartels.
Oh, yes, good afternoon, Judge. How are you?
Good, good. I hope you are as well.
Good, yes, thank you. Can y'all hear me okay?
We can.
Okay, thanks. Yes, Your Honor, I've spoken with Mr. Harper. He indicates that he does deny the allegations. He advised me that he had a pocket knife, a little pocket knife clipped inside his pocket, but he denies bringing it out or acting in a disorderly fashion. He indicates that he is employed full-time. He works at Hartsfield Airport, I'm told, at the parking garage there. According to pretrial services, it said he would qualify for a signature bond. So that's what we would ask for if the court is so inclined. And if not, we would ask for a $500 good bond on each of the two charges for $1,000 total. So nothing further from defense.
Okay, for each charge will be a $500 good bond, makes for a total of $1,000 good bond. Abide by any active MARTA restrictions, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Harper.
Thank you, Judge.
Welcome. Okay, and is this Miss Worthen?
Yes.
Yes, sir.
All right, very good. Good afternoon, Ms. Worthen. You have been charged in case, this is position 32, case 25 CR 003658G with the fray. Is there a history, Ms. Jackson?
There is one prior cycle. The last arrest was March the 21st, 2019, with the City of Atlanta Police Department for simple assault. There was no disposition for that arrest. She does appear to meet the criteria for UJR through the jail. Nothing in addition.
Yes, Mr. Siraka?
Yes, Judge, and I can elaborate a little bit further that 2019 simple assault was actually no prost. With respect to this incident, you've heard the facts. This was the fight at the Texaco between the two women over a man. Both of them sustained injuries. No primary aggressor could be determined, and there was a large crowd gathered around them as they engaged in mutual combat here. The state's recommendation for this case is a signature bond through pretrial services, a one-day anger awareness, no further contact with Samantha Moffett, stay away from the Texaco at 1117 Lee Street in Atlanta, and no drugs, weapons, or alcohol while out on bond.
Ms. McLeod, if agreeable with you, it will be $1,000 signature bond through the jail. No further contact with Ms. Moffett or Muffet. Stay away from that Texaco, and no drugs, alcohol, weapons while out on bond. Does that suit you?
That suits me, Your Honor, and I just wanted to say that my client lives right across the street, and she definitely was not the aggressor at all. She was essentially at her home when this other person came there to engage in a fight with her.
Okay, thank you. Good luck to you, Ms. Worthing.
Thank you, Your Honor.
Next is position 10, Mr. Everett.
Good afternoon, Mr. Everett. You have been charged in case 25 CR 003649G with loitering and prowling. Is there a history, Ms. Jackson?
Yes, Your Honor. There are 12 cycles. The last arrest was February 24th, 2025 for a failure to appear in Fulton County. He did receive first offender treatment in 2019 for criminal damage to property in the second degree. There was no seal date available. And he does have a misdemeanor conviction that was in 2017 for simple battery, family violence, and 2 counts of obstruction of an officer, and 2 counts of simple assault. He appears to meet the criteria for UJR level 4, nothing in addition.
Yes, Ms. Falk.
Yes, Your Honor, you've already heard the facts on this case. It's the co-defendant of Jerome Dean, with the defendants who were looking into the window at 2752 Deerwood Drive in Atlanta and were caught on surveillance video, as well as tampering with the air conditioning unit. The state's recommendation is a $1,000 surety bond, which is the preset bond from the magistrate court. Stay away from 2752 Deerwood Drive in Atlanta. No further contact with Quenisha Jackson, and no alcohol, drugs, or weapons, which is the same bond recommendation as the co-defendant.
Thank you.
Yes, Your Honor. I am asking for a signature bond for my client, Your Honor. He is unemployed and he tells me he's really not able to work. He actually lives at home with his mom. He doesn't have any money to pay for a bond, and he also denies that he was actually the person that they are saying was at this particular location, Your Honor. Given the fact that he has no significant criminal history, I think a signature bond is appropriate. Nothing further.
It will be $1,000 good bond. No further contact with Ms. Jackson. Stay away from the Deerwood Drive address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Everett.
Thank you, Your Honor.
Next is position 25, Mr. Payne.
Good afternoon, Mr. Payne. You have been charged in case 25 CR 003659J with theft by shoplifting and simple battery. Is there a history, Ms. Jackson?
Yes, there are 59 cycles. The last arrest was November 5th, 2022 in DeKalb County for possession of methamphetamine and possession of marijuana less than an ounce, and possession and use of drug-related objects. And that was in DeKalb County. And that was not presented to the grand jury. He does have prior felony convictions. One in 2017 out of Illinois for possession of a stolen vehicle, one in 2013 out of Illinois for an aggravated battery, and there are misdemeanor convictions. One in 2015 out of Illinois for domestic battery, one in 2012 out of Illinois for criminal trespassing. And he appears to meet the criteria for a UJR level 3, nothing in addition, Your Honor.
Yes, Judge, this incident took place June 17th, 2025. This was a delayed arrest. It took place at 2625 Piedmont Avenue in Atlanta. It's the Marshals. Law enforcement responded to a shoplifter call there. The defendant was captured on video entering the store and was witnessed by a loss prevention employee, Courtney Braithwaite, Brathwaite. The defendant removed several bottles and boxes of men's cologne and shirts totaling over $375 from their displays and placed them in a trash bag. The defendant then exited the store, passing all points of sale without trying to pay for any of the items. When approached by loss prevention, employee Braithwaite, outside of the front of the entrance, the defendant pepper sprayed that individual while the defendant was fleeing, pepper spraying behind him toward the ground, running away with the stolen merchandise. The use of the pepper spray was clearly intentional here. Mr. Braithwaite had eye irritation from this. The defendant, from the way they were able to locate him actually, was him being a frequent shoplifter at the Marshalls and other local areas in that sort of area there. They knew his name, knew his date of birth, and confirmed his identity by that, and were eventually able to find him and confirmed that he is the person that they showed him a photograph of. A warrant was issued, and as you heard from pretrial, quite the history here, multi-state offender. You have that aggravated battery from out of Illinois from 2013 is actually against a peace officer. You heard about the 2 domestic battery convictions. There's also an obstructing justice conviction out of Illinois, in addition to the theft convictions and other offenses. There was a robbery in Missouri, 2013, that was dismissed, but this is not his first rodeo with anything of the like. He has a notable history here with convictions of violence, obstructing law enforcement, and now he's using violence against people whose job it is to prevent crime for businesses like Marshalls. There's a risk of reoffense here, given that they knew his name and date of birth because he was a frequent shoplifter in the area. And the idea that he just went into the Marshalls, chose to take nearly $400 worth of merchandise and spray pepper spray behind him to prevent his capture. It's just crazy. He thinks he's in a movie, Judge. The state is asking for a $3,000 surety in total, $500 on the shoplifting, $2,500 on the simple battery. No further contact with Courtney Braithwaite. Stay away from Marshalls at 2625 Piedmont Avenue, Northeast Atlanta, and no drugs, weapons, or alcohol while out on bond. We have not spoken to the victim yet, but if the court could, we would ask that we sound for him at this time.
Mr. Braithwaite is on the line and wishes to address the court. Now is your opportunity. Does not appear so. Mr. McLean?
Thank you, Your Honor. Mr. Barry Payne is 48. He has a stable mailing address on Washington Street in a program. He's been associated with PAD recently. He's a high school graduate, and he's worked in landscaping, warehousing, and construction. He's 48 years old. He asked the court to set an appropriate bond for him. He's asking the court to consider signature bond if that is possible, because of the number of counts and the nature of the matter rather than the number of prior arrests. He admits he has quite a few. Thank you.
For the theft charge will be a $500 good bond. For the simple battery, a $1,500 good bond makes for a total of a $2,000 good bond. Stay away from all Marshalls. No further contact with Mr. Braithwaite. No drugs, alcohol, weapons while out on bond. Good luck, Mr. Perry. Mr. Payne, excuse me.
Next is position 4, Mr. Campbell.
Good afternoon, Mr. Campbell. You have been charged in case 25 CR 003646B with criminal trespass. Is there a history, Ms. Jackson?
Yes, Your Honor. There are 12 cycles. The last cycle was August the 1st, 2024, out of Cobb County for obstruction of an officer for reckless conduct. There was no disposition for that arrest. He does have misdemeanor sentences and convictions. Received a nolo contendere sentence in 2018 out of Clayton County for criminal trespassing and disorderly conduct. There was a conviction in 2014 out of DeKalb County for theft by shoplifting, one in 2012 for theft by taking. He received a nolo contendere sentence in 2009 out of Smyrna, Georgia for theft by shoplifting and furnishing to purchase or possession by a person below the legal age of alcoholic beverages and driving without a valid license. He appears to meet the criteria for UJR level 2. Nothing in addition, Your Honor.
Yes, Ms. Falk.
Yes, Your Honor. This incident happened June 28th, 2025 at the World Congress Center, Georgia World Congress Center at 20 Andrew Young International Boulevard Northwest. The defendant had been previously given a trespass warning on March 9th, 2025 by Officer Stevens and a copy of charges on June 15th, 2025 by Sergeant Wicks, advising him he was criminally trespassed and if he was continued to return, he'd be placed under arrest. The defendant was then found on the location in the staircase sleeping on June 28th, 2025, and was subsequently placed under arrest due to the two previous citations that had been issued to him. The magistrate court set the bond at $10, a $10 surety bond. Stay away from 20 Andrew Young International Boulevard, which is the Georgia World Congress Center, and no alcohol, drugs, or weapons. That's the state's recommendation. That's all for the state.
Thank you. Ms. Tucker?
Yes, Your Honor. Mr. Campbell is a 34-year-old Atlanta native. He was able to provide me with a good mailing address for him. He's completed some college, completing an associate's with medical assistance. He does say he's employed, selling things, I guess doing odd jobs for income, but not consistent. He doesn't have any failure to appears on his record. He has no objections to stay away from the Georgia World Congress Center. We're requesting a signature bond on his behalf. He, even with the $10 surety that's been set, he was asking if he could do time served because he wouldn't be able to get out on that bond. So we are requesting a signature bond for him today.
And Your Honor, if Mr. Campbell is asking to resolve this case today, the state is more than happy to make an offer to Ms. Tucker that she can convey to her client. We can resolve this today.
I'm definitely willing to speak with him, relay any offers.
Campbell, we will be back with you. I'll have Ms. Tucker speak with you.
Thank you.
You're welcome. So once you get the offer, we will have you speak with him over the phone. Do we have anyone else that we can take while we're waiting that?
Next is position 7, Mr. Devine.
Good afternoon.
Good afternoon, Mr. Devine. You have been charged in case 25 CR 003652A with theft by shoplifting. Is there a history, Ms. Jackson?
Yes, Your Honor, there are 17 cycles. The last arrest was September the 20th, 2023 with the City of Atlanta Police Department for driving while license suspended or revoked. Does have prior misdemeanor convictions. This one in 2023 for 3 counts of reckless conduct. One in 2015 out of Minnesota for disorderly conduct. One in 2011 out of Tennessee for driving while license suspended or revoked and possession of marijuana less than an ounce. He appears to meet the criteria for UJR level 3. Nothing in addition.
Yes, Ms. Falk.
Yes, Your Honor. This incident happened at the Home Depot at, let me see, April 25th of 2025. The defendant entered that location on that date and stole, it looks to be $134.40 worth of lumber. It actually amounted to 30 pieces of lumber. He entered the store, took the lumber, and walked past all points of sale, past the checkout area, and drove away in his 2003 Hummer H2 that was parked in front of the store. The entire incident was recorded on the store surveillance cameras. The officers were then able to identify the defendant on May 23rd, 2025, when Miss Rodriguez, who was the individual who, an employee at the store, stated she recognized the defendant as someone who had visited the store before and engaged in similar activity at other Home Depot locations. She mentioned he had been at the store a few days before this incident and expressed confidence in her ability to recognize him again. Officers then ran a tag information through Ominix, which identified the vehicle as belonging to Ellis Devine. They took a driver's license photo, placed it in a 6-pack lineup, and Miss Rodriguez did identify the defendant as the person that she observed. This defendant currently has a $1,000 surety bond for the theft by shoplifting. The state asked that that bond remain as set, that the defendant be have a stay away order from all Home Depot stores, not just the Home Depot located at 650 Ponce de Leon where this happened, due to the fact that Ms. Rodriguez did state that she identified him as someone who engaged in this activity at other Home Depot locations. She is the loss prevention officer, so she would be aware of the other theft by shopliftings in the area that had been done by Mr. Devine. And we also ask for no alcohol, drugs, or weapons as part of this bond. As I stated, this $1,000 surety bond was preset by the magistrate court. That's all for the state.
Thank you, Ms. Tucker.
Yes, Your Honor. Mr. Devine is 37 years of age. He's resided in the Atlanta area for 8 years now. He's completed an associate's degree and he's currently enrolled in the IT program at Phoenix University. I'm sorry, at the University of Phoenix. He currently works a landscaping business. So we're actually objecting to the stay away from all Home Depot locations. We have no allegations to support the facts that he has allegedly been accused of theft at other locations. We have no objections to a stay away from this specific location, but we are asking that he be allowed at other Home Depots, as he does frequent these locations for his landscaping business. He does maintain that he is innocent of these charges, that anytime he goes to these stores, he's rung up by a cashier. We are requesting a signature bond on his behalf. He has recently attended court on other charges and is required to pay $5,300 in bond on his other charges, and he wouldn't be able to pay any more in bond on the bond. And this is the last charge he has to handle so that he can get out. He does have 5 children and a pregnant wife at home that he's trying to return home to and return back to work. And so we're requesting a signature bond on his behalf so that he's able to get out of jail and handle.
And Your Honor, just, oh, sorry, Ms. Tucker, I did not mean to interrupt.
You can go ahead, sir.
The other charges, Your Honor, under 25 PI 005211, 3 counts of VGCSA and 1 of possession of firearm. That's what Ms. Tucker is referring to with the other charges.
Thank you. It will be a $3,000 signature bond through pretrial level 2. Stay away from all Home Depots. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Devine. Tucker, have you got any information that you need to speak with the other gentleman? Ms. Tucker?
Yeah, just received a message from Ms. Vogt.
Okay, so
I'm
courtroom
gonna
2.
call courtroom 2 now.
Okay, if you can make, I believe it's Mr. Campbell available for Ms. Tucker when she calls. Thank you.
Your Honor,
Yes, Mr. McLean.
if we're between cases, let me interject. I've been having trouble interviewing the 17-year-old Mr. Roman Vasquez. We tried the number. There's no answer at South Annex on the 7122 extension. I just need to talk to him before court.
Okay, so we'll make note that we need to have someone, we can have someone get in touch with South Annex to make him available.
Thank you.
Ms. Champion, are you able to do that for the court?
If someone can South Annex number in the chat, I can call them. If we get a courtroom to possibly can put South Annex number in the chat.
All right, so courtroom 2, if you can put the South Annex number in the chat for us, please.
Good afternoon, Your Honor. Good afternoon,
Good,
everybody.
good afternoon, Officer Milton. Good to see you.
Good to see you too, sir. It's
Give-
in the, go ahead,
No, they have somebody seated there for me, Officer Milton.
no problem.
Okay, who do we have there?
Position 8, Mr. Dodson.
And who's representing Mr. Dodson?
That's Ms. Tucker.
I want to make, Mr. Bartels, is that you?
No, Your Honor. I believe Ms. Tucker has the first 1/3 of the calendar. I have the second 1/3 if the court wants to start with any of those cases.
Okay, so I believe that Ms. Tucker's on the phone, so would you
Right,
mind,
she's
courtroom 2,
talking.
if I went to ACDC?
Think a lot of her people.
Courtroom 2?
Yeah, yes, Judge, that's fine.
Okay, and I'll come back as soon as Ms. Tucker's available. Yes, ACDC. Good afternoon, ladies. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you do not have a private attorney this afternoon, we are providing you with the assistance of a public defender or conflict defender if you choose to utilize their service. Officer Milton, if you can, Ms. Tucker is busy at the present time, so someone that's
Yes.
not her client, please.
Yes, I have 3 that belongs to Attorney McLeod. Position 5, Ms. Dancy. Ms. Dancy, come on. You not Dancy?
Okay. Good afternoon, Ms. Danzy. You have been charged in case 25 CR 003647F with 3 counts of battery family violence and simple battery family violence. Is there a history, Ms. Jackson?
Yes, there are 6 cycles. The last arrest was July the 15th, 2023 in Douglas County. Theft by receiving stolen property and possession of Schedule 1 or 2 controlled substance. She does appear to be on probation, first offender probation in Douglas County for theft by receiving stolen property and possession of Schedule 1 or 2 controlled substance. That disposition date was October the 21st, 2024, and the term is for 5 years. And she appears to meet the criteria for UJR level 1. Nothing in addition, Your Honor.
Thank you. Ms. Falk?
Yes, Your Honor. This happened June 28th, 2025 at 2900 Laurel Ridge Way, apartment 10808 in East Point. Officers received a call, spoke with Brittany McCrary, who was holding a wet rag to her left eye. She removed it, and the officers could see her eye was substantially bruised with black and red markings. She stated that the defendant, who is her ex-girlfriend, punched her with a closed fist, and they had been living off and on at that location for the last few months. Ms. Danzy was spoken to, the defendant was spoken to. She stated she was woken abruptly by the defendant, Ms. McCrary, banging on the bedroom door, and that she tried to stop her from opening the door, and that resulted in a small scratch on her right foot. That did not quite get to everything that occurred, so Ms. McCrary was spoken to further. She stated there was an argument about text messages, that the defendant was laying on the bed at the time. She jumped up from the bed and began to charge at her, began throwing closed fist punches at her head. Ms. McCrary stated at that point she put her forearms up to block her head and face from the incoming blows, and then the defendant threw an uppercut that connected with her left eye, causing the bruising. Upon that point, the officers did take a look at her forearms, and they did show signs of the defensive wounds that Ms. McCrary described, which were consistent with her trying to block blows coming at her from the defendant. Based on that, the defendant was determined to be the primary aggressor and was placed under arrest. We have had an opportunity to speak with Ms. McCrary. She stated that she and the defendant are no longer a relationship. They live together at the location. This was not the first time that the defendant has been violent toward her, but it is the first time police have been called. She states she is not in fear. The defendant is okay with no violent contact. However, she also wants the defendant to stay away from the residence. She is asking for a one-time police escort, and she stated she will try to be here today on the Zoom. We are asking for a $5,000 surety bond, $3,000 on the battery, $2,000 on the simple battery. No further violent contact with Bridget McCrary. Stay away from 2900 Laurel Ridge Way in East Point. No alcohol, drugs, or weapons, specifically no firearms, and 2 days of anger management. At this time, the state would like to call for Ms. McCrary, and that's all for the state.
Does not appear so. Ms. McLeod?
Yes, Your Honor. I would ask the court to consider signature bond for my client. She has no significant criminal history, Your Honor. And she tells me that if the court orders that she cannot stay at that location any longer, that she does have somewhere else that she can go. And she's okay with no further contact, if that is what the court orders, or no further violent contact. She's also okay with that. And nothing further, Your Honor.
Okay, for each of the battery charges will be a $2,000 signature bond through pretrial level 2. For the simple battery, a $1,000 signature bond through pretrial level 2. Makes for a total of a $7,000 signature bond through pretrial level 2. 2 days of anger awareness. No further contact with Ms. McQuarrie. Stay away from the Laurel Ridge Way address. She can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good
Thank you,
luck to you,
Honor.
Ms. Danzy. You're welcome.
Position 25, Ms. Marmon.
Ms. Milton, we're gonna go 1 and 1, okay? I got position 13, Mr. Hall.
Okay. Good afternoon, Mr. Hall. You have been charged in case 25 CR 003667E. Simple battery, 2 counts of simple battery family violence.
Why did my thing go to mute? Can you hear?
Okay, let's see. Ms. Jackson, is there a history?
Your Honor, there are no prior arrests on file. He appears to meet the criteria for UJR. Go to jail. Nothing in addition.
Thank you. Mr. Nixon?
Yes, Your Honor, this incident occurred on June 28th, 2025. Corporal was dispatched to 7837 Lakes Drive in reference to a domestic dispute. And upon arrival, the corporal spoke with the defendant, who appeared to be under the influence of alcohol. And the defendant advised he and his wife were having a dispute about personal issues the two of them were dealing with. Now, the defendant stated that the conversation was overheard by their children, and shortly after, they entered the room to see what was going on. The defendant was seen grabbing his wife's belongings and throwing them into the hallway, telling her she needs to leave. The defendant stated his son, Jarrell Hall, the victim, started to get into his personal space, so he began to push him away. The defendant advised that during the altercation, the victim brought up his grandmother, which caused him to lose it, in his words, and he told the victim he could leave his home as well. The defendant admitted he was standing in his bedroom doorway when he shoved the victim out of his bedroom because he could not leave the room. The defendant also admitted he pushed the victim 3 times, and on the 3rd time, he slipped and fell on top of the victim, which was the end of the altercation. Now, the victim stated he was standing in his parents' bedroom while his mom packed her belongings to de-escalate. And the victim stated that while waiting on his mother to pack, the defendant told him he has to leave the home as well and began to shove him. The victim stated after being shoved multiple times, the defendant smacked him in his chin, which caused the altercation to ensue. Our office was able to speak with the victim. The victim is the son of the defendant. They lived together at the incident location. The victim confirmed the events in the warrant and stated that nothing like this has ever happened before. Victim stated that he is not in fear of the defendant and wants to continue contact and wants the defendant to return to the residence, and stated he does not wish to even press charges. Per the criminal history and or the lack thereof and the facts of this case, Your Honor, the state is going to recommend SOB through pretrial, no further violent contact with the victim, no alcohol, drugs, or weapons while out on bond, anger awareness, and the state would ask the court to sound for the victim when appropriate.
Can you give me the alleged victim's name, Mr. Nixon?
Yes, Your Honor. Jarrell Hall.
If Jarrell Hall is on the line and wishes to address the court, now is your opportunity. Mr. Bartels?
Yes, thank you, Your Honor. We are in concurrence with the state's recommendation for the signature bond. I'm told that Mr. Hall has been in Georgia for 15 years, and he works full-time for Transocean. He does offshore drilling. And I was not able to reach his son, Jarrell, but I did speak with his wife, and she told me essentially the same as what Mr. Nixon said about his son's position on this matter. So we would just ask for the signature bond and then no further violent contact.
Do you know how old Jarrell is, Mr. Bartels?
I'm told he is an adult. I believe he's in his 20s. He did Mr. Hall did mention to me his son was an adult, but I don't see a date of birth.
He's 24, Your Honor.
Yeah.
Thank you. As such, for each of the charges will be a $2,000 signature bond through pretrial level 1, makes for a total of a $4,000 signature bond through pretrial level 1, 2 days of anger awareness, no further violent contact with Jarrell Hall, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Hall.
Thank you, Judge.
You're welcome.
Next, we have position 24, Ms. Marmon, Attorney McLeod's client.
Judge, and this was a dual arrest with position. Where is it? It is Miss Troutman. So that's 29, Judge.
Okay. Do we have, is Ms. Troutman available in one of the courtrooms?
She's here at HBC, Your Honor.
Okay, we'll take her next then. And who represents Ms. Moman?
I do, Your Honor.
Okay, thank you, Ms. McLeod. Good afternoon, Ms. Moblin. You have been charged in case 25 CR 003657A with a fray. Is there a history, Ms. Jackson?
There are 19 cycles. The last arrest was March the 28th, 2019 in Fulton County for giving false information to an officer and the sale of marijuana. There was no disposition for that arrest. There are prior felony convictions, one in 2016 for aggravated assault, one in 2011 for aggravated battery, and there are misdemeanor convictions, one in 2011 for a local ordinance, and one in 2006 for disorderly conduct. There's an additional one in 2006 associated with the CWAC, one in 2004 for battery. She does appear to meet the criteria for UJR level 3. Nothing in addition.
Mr. Sirocco?
Yes, Judge. So this incident took place yesterday at 2608 Donald Lee Hollowell Parkway, Northwest in Atlanta. It's a rooming house known for alcohol and frequent drug abuse. Law enforcement responded to a dispute with a weapons call. Officer made contact with Annette Moman and Pamela Troutman. Ms. Moman refused to provide a statement. Ms. Troutman stated she'd come home to use the restroom when words were exchanged with Ms. Moman. Ms. Troutman stated that Ms. Moman told her to get away from the door, then grabbed a black milk crate and hit her on the shoulder. Ms. Troutman then stated she ran inside her room, and when leaving, Ms. Moman had 2 knives in her hand, which Troutman reached for, causing both of them to fall to the ground. This was like outside the location. Ms. Troutman stated that Moman grabbed a hammer and struck her on the head, after which Troutman had cut her on the right thigh, causing a cut, leaving a laceration. And Troutman then ran out to call 911. Ms. Troutman had visible injuries to her right thumb, pinky. There was an abrasion to her head, the left side of her head. And Ms. Moman sustained injuries to her right thigh, bicep, forehead. Officers observed that Troutman was rambling and her statements were inconsistent with new information when officers kept asking for clarity. There's suspected drug use here, and there were drugs found on the premises. Officers found 2 knives and a hammer in Ms. Moman's room. And the milk crate, however, Ms. Troutman claimed that was used as a weapon, appeared undisturbed and neatly stacked, and the knives and the hammer showed no blood residue. Ms. Moman's sister came by to check on Ms. Moman because she had apparently called her stating that the defendant had been harassing her that day, and an anonymous male whose uncle owns the property stated that Troutman is a troublemaker. Both parties were arrested here, Judge. You have inconsistencies and consistencies here from Ms. Troutman. The finding of the hammer, the injury to her head, the finding of the knives. Then you have her inconsistencies, the crate being in order, nothing on the weapons in terms of blood or anything like that, and the suspected drug use here. Regardless of who started what or what this altercation looked like physically, we know that it happened. They both sustained injuries. And as for Ms. Moman, there's a substantial criminal violent history here. You have that 2016 aggravated assault, 2011 aggravated battery, the former being for stabbing a man repeatedly with a knife, the latter being for shattering a woman's knee. And there's also a 2004 battery conviction as well. For these reasons, the state is asking for the court to leave as is the $2,500 surety that was preset by the magistrate court, 2-day anger awareness, no further contact with Pamela Troutman, no drugs, weapons, or alcohol. And we would ask the defense who exactly is living where in terms of determining who shouldn't be where, because these two shouldn't be living with or near each other, whatever that living situation is.
This is a rooming house, that is my understanding. I have spoken with my client, and she tells me that she and Miss Stroutman have long made up any kind of disagreements that they had. They've had the opportunity to talk in jail. They both live at this location. My client is unemployed and also has some disabilities, so she needs a roof over her head. She's 66 years old. So I think, based on what my client is telling me, that neither of them should have to move. It's going to be an extreme hardship for both of them if they have to find other accommodation. I know certainly for my client, she's on SSI. She has many other issues. She just doesn't have anywhere else to go. She really wants to have contact with Miss. She's okay with having contact with her. She says they've resolved their differences.
State would object to that given the history and also the freshness of this. This was yesterday.
Okay, Mr. McLean, are you representing Ms. Troutman? Or will be representing Ms. Troutman?
Appears to be Mr. McLean on.
Mr. McLean, I can't hear you.
Yes, it's Mr. McLean. He's on the phone talking to Vasquez.
Oh, okay. I see him on the screen here. Are you with me, Mr. McLean? I can't hear Mr. McLean. While we try to get Mr. McLean's input, I'm gonna keep them both away from the rooming house. I don't know who's supposed to be there, who doesn't supposed to be there. I know that if it were my rooming house and there was this type of altercation, I wouldn't want either one of them there. So I'm gonna have both of them not be at that rooming house anymore and stay away from one another. I will give her a signature bond, though. It will be a $2,000 signature bond through pretrial level 2. No further contact with Ms. Troutman. Stay away from the rooming house on Donnelly Parkway. She can go back there on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond.
Thank you, Your Honor.
Welcome. Good luck to you, Ms. Moman. Mr. McLean, are you with me?
Yes, Your Honor.
Okay, and I'm going to go back to ACDC and take Ms. Troutman so that we can, given that these are the same situation.
Good idea.
Okay, Ms. Troutman, good afternoon. You have been charged in case 25 CR 003656A with possession and use of drug-related objects and a fray. Is there a history, Ms. Jackson?
Yes, Your Honor, there are 22 cycles. The last arrest was November the 29th, 2021 in Cowardly County, Georgia, for a probation violation. She does appear to be on probation in Fulton County. That case number is 21 SC 178004 for aggravated assault. That disposition date was November the 24th, 2021, and the term is for 1 year of confinement and 9 years of probation. There are prior felony convictions. One in 2020 out of Cowardly County for possession of Schedule I controlled substance. One in 2011 for aggravated assault and possession of a firearm during commission of a felony. One in 2009 for aggravated assault. One in 1997 out of Cowardly County for possession of controlled substance. There's one misdemeanor conviction in 2006 for disorderly conduct. She does appear to meet the criteria for UJR level 3, Your Honor. Nothing in addition.
Yes, Mr. Soraka.
Thank you, Judge. You're familiar with the facts here. This was the rooming house situation at 2608 Donald Lee Hollowell Parkway in Atlanta. both parties were observed with injuries, and there was suggestion of drug use here, inconsistencies from Miss Troutman, and both parties were ultimately arrested here. Not unlike the case we heard recently. This is there's a history of violence here. You have that aggravated assault, that pretrial mention from 2021. That was an aggravated assault against an elderly person and a possession of firearm or knife during commission or attempt to commit certain felonies for stabbing an elderly man with a knife. Battery family violence. This one might have gone under the radar, but I did find this from 2019, amended from aggravated assault for cutting a man with a knife. So clearly an issue with weapons and anger here. There was the other aggravated assaults from 2011 and 2009 as well. And I see there's a most recent FTAs were 2020 and 2019. So the state's recommendation, not dissimilar to the previous, is that the bond remain as set at $2,500, surety, 2-day anger awareness, no further contact with Annette Moman, and stay away from the residents there. No drugs, weapons, or alcohol while out on bond.
Mr. McLean?
Your Honor, Ms. Troutman does receive disability check. She had gotten some damage from being in a truck wreck back in truck hit her back in 2006. She has close community ties. I have her daughter's number. I have her aunt's number. She is a high school graduate. And we would ask the court to set the bond as low as possible for this situation.
All right, for the possession of drug-related objects.
Judge, I apologize. I should have made this announcement. We have no pros that charge. We're just proceeding on the affray. So that's all you need to worry about. And that has been sent. Ms. Sanders should have it in her inbox.
Okay. For the affray, a $2,000 signature bond through pretrial level 3. No further contact with Ms. Moorman. Stay away from the rooming house and Donnelly Parkway. She can go back there on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Troutman.
Mr. McLean, were you done with, were you ready for Mr. Vasquez?
No, not quite. He was trying to give me some information. I think probably no more than 2 or 3 minutes more.
All right, we can go to position 16, Mr. Harris.
Good afternoon, Judge.
Good afternoon. Good afternoon, Mr. Harris. You have been charged in case 25 CR 003670G with battery, simple battery, and willful obstruction of law enforcement officers. Is there a history, Ms. Jackson?
Yes, there are 9 cycles. The last arrest was February the 27th, 2024 in Fulton County for theft by shoplifting, a felony, and obstruction of an officer. And there was no disposition for that arrest. He does have appear to have an outstanding hold out of North Carolina for a probation violation. Underlying charge was not listed. The date on that warrant was August the 28th, 2015. It was 1 misdemeanor conviction. It's in 2018 out of Cowardly County for driving while license suspended or revoked and obstruction of an officer. Nothing in addition. He does appear to meet the criteria for a UJR level 3. Nothing in addition.
Mr. Jackson?
Yes, Your Honor. I did note, I don't know if I heard it, the Arizona criminal history is 2021 assault, disorderly, resisting arrest, possession of dangerous drugs. In 2022, 4 counts of ag assault with a deadly weapon, 5 counts of ag assault on an officer, 3 counts of resisting arrest, and 4 counts of failure to obey police officer. This incident occurred on June 27, 2025. The officer received a call from dispatch regarding a simple battery that occurred at Moreland Avenue, Euclid Avenue in Atlanta. Officer arrived on the scene and met with the victim, Pierre Ridge, and Pierre Ridge appeared to have been involved in a physical altercation as a result because there was a laceration over his right eye and cuts on his hands. Officer asked Pierre what happened. Pierre stated that he had been assaulted by two suspects in front of Hydropop's smoke shop located at 1087 Euclid Avenue, Northeast Atlanta. And Pierre received a laceration over the top of his right eye and several cuts across his right hand knuckles. Mr. Ridge stated he could physically point the suspects out if he were able to locate them. And the officers canvassed the area for the suspects and were able to locate one suspect, the defendant. And officers detained the defendant until Mr. Ridge was on the scene to identify the suspect, and Mr. Ridge gave a positive identification of the defendant. Per the facts in this case, Your Honor, and the criminal history previously mentioned, the state is going to ask for $5,000 surety for the battery, $1,000 surety for the obstruction, and $1,500 surety for the simple battery. No further contact with Pierre Ridge. No alcohol, drugs, or weapons while out on bond. A stay away from 1087 Euclid Avenue, Atlanta. 2-day anger awareness. And the state would ask that the court sound for the victim when appropriate.
Mr. Ridge is on the line and wishes to address the court. Now is your opportunity. Does not appear so. Mr. Bartels?
Yes, thank you, Your Honor. I have spoken with Mr. Harris about this incident. He does deny that he was the primary aggressor. He advised me that he is self-employed. He makes jewelry and different pieces of art that are sold at this store, the Crystal Blue. That's why he was there, was because he does business with the owners of the store. He indicated that Mr. Ridge had been asked to leave the location by the store owners, and he did not want to leave, and that Mr. Ridge was the primary aggressor. If Mr. Ridge has injuries to the knuckles on his right hand, that would tend to support that. So Mr. Harris does indicate that this was done in self-defense. He is asking for a signature bond. It appears from pretrial services that he would qualify. If the court is not inclined to grant the signature bond, we would ask for $1,000 good bond on the battery and a $500 bond on the obstruction. Nothing further from defense.
Okay, for the battery, it'll be $1,000 good bond. For the other two charges, a $500 good bond makes for a total of a $2,000 good bond. No further contact with Mr. Ridge. Stay away from the incident location. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Harris.
Thank you, Judge.
Welcome.
Next is position 19, Ms. Johnson.
Good afternoon, Ms. Johnson. You have been charged in case 25 CR 003673J with battery and simple battery. Is there a history, Ms. Jackson?
I'm pulling that file down, Your Honor, just a moment, please.
And Your Honor, just to let the court know, this is a co-defendant case. She's a co-defendant with Mr. Grant, and I'll be representing Mr. Grant.
Okay, Mr. Grant, let's see. Position number 12. Courtroom 2, do we have Mr. Grant?
I can get him real quick. He's right outside the door. I get him.
Okay, so we can do them both at the same time. Thank you. And let's see, who's going to represent Mr. Grant? Is that you, Mr. Bartels?
Yes, Your Honor, that is my case.
Okay, very good. Good afternoon, Mr. Grant. Position number 12. You have been charged in case 25 CR 003666E with battery and simple battery. Ms. Jackson, let's start with Ms. Johnson. Is there a history?
There are 13 cycles. The last arrest was October the 22nd, 2022 in Fulton County for burglary in the first degree and battery and criminal damage to property in the second degree. He does appear to be on probation for those charges. That case number is 24 SC 003972. That disposition date was January the 13th, 2025, and the term is for 3 years. He does have a prior felony conviction since 2003 for possession of marijuana with the intent to distribute. And he does have a misdemeanor sentence and a conviction. He received a no contendory sentence in 2009 out of Clayton County for affray and giving false information to an officer. And there was one in 2003 for affray. And she appears to meet the criteria for UJR level 3. Nothing in addition, Your Honor.
Ms. Jackson, are you with me?
Can you hear me, Your Honor?
Now I can. I think you were on mute. This is a co-defendant. Do you have the history for position 12, Michael Grant?
Yes, Your Honor. There are 12 cycles. The last arrest was March the 12th, 2023 for aggravated battery. And that was in Fulton County. There was no disposition for that arrest. And he does appear to have a prior misdemeanor conviction since 2008 for disorderly conduct. And he was recommended for UJR level 3. Nothing in addition, Your Honor.
Thank you. Yes, Mr. Nixon.
Yes, Your Honor. The facts of this case are as follows. This incident occurred on June 29th, 2025. The defendants, Johnson and I believe Grant in position 12, kicked and stomped the victim, Derek Burton, while he was on the ground, causing a bleeding and laceration to his head. You heard the criminal history for defendant Johnson with regard to the 2025 burglary, battery, criminal damage to property in the second, which she's on probation for 3 years, as well as, so I scroll down here. Yes, as well as defendant Grant with regard to, I think, 3 FTAs and a recent 2025 felony FTA, as well as the 2023 ag battery arrest, where he received a $30,000 surety on that charge. For both defendants, the state is requesting $2,000 surety for the battery and a $1,000 surety for the simple battery. No further contact with the victim, Derek Burton. Stay away from 455 5 Washington Road in Atlanta. No alcohol, drugs, or weapons while out on bond, as well as 1-day anger awareness. And the state would ask the court to sound for the victim when appropriate.
Derek Burton is on the line and wishes to address the court. Now is your opportunity. Does not appear so. Ms. McLeod?
Yes, Your Honor. My client denies that she was involved in anything concerning this alleged victim, Your Honor, and she has expressed great surprise to me that she was even arrested. She lives at this particular location. It's an apartment complex. She has her own apartment, which she gave me the number for. So if she is, as the state is suggesting, if she is unable to go back to that location, she's essentially going to be homeless. I believe I heard pretrial say that she met the criteria for signature bond, and I would be asking the court to consider that for my client, Your Honor. And also that she be able to go back to where she lives. Nothing further.
Mr. Bartels?
Yes, thank you, Your Honor. I have spoken with Mr. Grant, and he too expressed surprise that he was charged with this. He denied that this incident took place, and he indicated that he is employed full time. He works at My Grant Glass Company. He drives a glass truck. He's been in Georgia since 1999. He has family in the metro Atlanta area, including his parents and his siblings. So he does have ties to the community. If he qualifies for a signature bond, which he apparently would, according to pretrial, we would ask for a UJR. If the court is not inclined to do that, I would ask for $1,000 charge on the battery, or $1,000 bond on the battery, 500 on the simple battery. That really does look like a lesser included offense. It's two charges based on the same incident. So we would ask the court to keep that in mind for bond. Mr. Grant indicated to me that he's actually in the process of moving out of this location. So I don't think we would have a problem with a no further contact order. We would just ask that he be allowed to return and get his belongings as needed. Nothing else.
Okay. And Mr. Nixon, the 455 Washington Road, is that an apartment complex that Mr. Burton has his own apartment within the complex?
I'm not sure. Let's see if, let me reach out to my office for 1 second.
Well, I'm just gonna have them stay away from Mr. Burton's residential address, but I'll need to know where that is, okay? All right, so for Ms. Johnson, position number 19, for the battery, $500 good bond. For the simple battery, a $500 good bond makes for a total of $1,000 good bond. No further contact with Mr. Burton. Stay away from his residential address, his apartment. No drugs, alcohol, weapons while out on bond. For position number 12, Mr. Grant, for each charge will be a $500 good bond, makes for a total of $1,000 good bond. No further contact with Mr. Burton. Stay away from his residential address, his apartment. No drugs, alcohol, weapons while out on bond. And Mr. Nixon, if you find that address, the apartment number, if you can put that into the chat for Ms. Bridgewater, please.
Yes, Your Honor. Thank you.
Thank you.
Thank you, Judge.
You're welcome. Good luck to you both.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, thank you, Ms. McLeod. We'll see you
You're
next
welcome.
time. Have a good rest of your day.
You too, Your Honor. Thank you.
Thank you.
Next is position 30, Mr. Vasquez.
Okay, good afternoon, Mr. Vasquez. You have been charged in case 25 CR 003661J with simple battery family violence. Is there a history? Ms. Jackson?
Just a moment. I'm pulling Mr. Vasquez in.
I didn't have any, Judge.
There are no prior arrests on file, Your Honor. He does
Okay.
appear to meet the criteria for UJR through the jail. Nothing in addition.
Thank you. Mr. Siraka?
Thank you, Judge. This incident took place June 28th, 2025 at 445 Willow Creek Road in Fairburn. Law enforcement was dispatched to a physical altercation between a stepfather and his stepson. Upon arrival, officers made contact with the victim, Mr. Miguel Cabrera, who explained that the defendant, his stepson, who lives in the same house with him there, had struck him during a physical altercation. Mr. Cabrera stated that the defendant was trying to burn a piece of paper using the stove and that he asked the defendant to stop. Defendant refused. Mr. Cabrera then attempted to turn the stove off, at which point the defendant struck him in the jaw with a closed fist. The defendant admitted he was trying to burn a piece of paper when his stepfather turned the stove off, that he became upset and then struck him in the face. Mr. Cabrera stated that similar incidents had occurred in the past. The defendant was placed under arrest. We have spoken with both the victim and the defendant's mother. The victim explained, yes, he is the stepfather of the defendant and they do live together. He confirmed the events in the warrant. He stated that this is not the first time the defendant has done this. He stated that the defendant had been trying to burn paper on the stove for the past several days, and that the defendant's behavior is a constant problem. He says the defendant acts out and punches holes in the wall, and that police have been called several times, and they would ultimately take him to the hospital, where he would be 1013. He explained that the defendant may need MHET and that he does not want contact with the defendant and wants him to stay away from the residence. With the victim's mother, the defendant's mother, victim's spouse, she explained that this is a constant issue as well with the defendant. She says the defendant has attacked her in the past, has choked her, and that police have been called before. She stated that the defendant punches holes in the wall and that she is in fear of the defendant and does not want him to return to the residence. She does not know what his living situation would look like, but we have two people saying they don't want contact and don't want him there. And we need to prioritize their safety. From what they're saying here, it's clear he presents a risk of reoffense, risk to their safety, and this is not a one-off incident. So, state is seeking a $2,000 surety for the defendant to complete FFIB, undergo MHET, if any treatment is recommended. No further contact with Miguel Cabrera. Stay away from 445 Willow Creek Road in Fairburn, and no drugs, weapons, or alcohol while out on bond. And we would ask the court sound for the victim at this time.
Mr. Cabrera is on the line and wishes to address the court. Now is your opportunity to do so. Also, if Mr. Vasquez's mother is on the line and wishes to address the court, you also have that opportunity.
Yes, hello.
Yes, good afternoon, ma'am. Can you tell me your name?
Mariela Vasquez.
Yes, ma'am. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down, Ms. Vasquez. What would you like to tell the court?
Yes, so we do request no contact. We are in fear for our safety and our 3 youngest kids. He has been to the hospital 4 different times and is not compliant with his medication. So he does need further evaluation with that, but I haven't been able to give it to him because he refuses.
Okay, and your son is 17, is that right?
Yes.
Okay. I take it that any other family members that he could reside with or not?
No, not at this time.
Okay. I appreciate you being here, ma'am. Thank you.
Thank you.
Mr. McLean?
Your Honor, thank you. He is 17, of course, and the situation is such that we would need a social worker visit to advise him if the court chose, because of the nature of the allegation, if the court chose to treat him as an emancipated time to let him sign his own bond, we would need to advise him as to housing.
Okay, I want him to have a social worker visit to assess for an MHET. I do not want to put this young man just on the street. I also don't want to have him in custody any longer than necessary. Ms. Bridgewater,
Yes, sir.
can we put Mr. Vasquez on my SAP calendar on the 8th instead of the 15th of July?
I will.
Mr. McLean, I would like for you to have this social worker and whoever's handling this at the SAP calendar, see if we can come up with some type of plan for Mr. Vasquez, so that if I can modify the bond and give him a signature bond, that I have someplace that he can go or something of that nature, or if he's in a need for additional services, I'd appreciate knowing that at that time. Is that doable?
That's doable. I've been in touch with a social worker about this issue.
Right. Okay, so let's do that. So at this time, it'll be a $2,000 good bond. per the state's request, no further contact with the alleged victim, stay away from the Willow Creek Road address, a one-time escort with police to get any belongings, no drugs, alcohol, weapons while out on bond. I will reevaluate this on the 8th to see if we can find some placement. Okay, or if he needs other services.
Very good.
All right, thank you all. I appreciate it.
Thank
Good
you.
luck to you, Mr. Vasquez.
Thank you.
You're welcome, ma'am.
Next, we have position 14, Ms. Hall.
Good afternoon, Ms. Hall. You have been charged in case 25 CR 0036688Y with 2 counts of battery family violence and simple battery family violence. Is there a history, Ms. Jackson?
There are 3 cycles. The last arrest was July the 21st, 2019 in Fulton County for affray and obstruction of an officer. There was no disposition for that arrest. He does have 1 misdemeanor sentence. So in 2018, he received first offender treatment. 2018 out of DeKalb County for interference with custody. That case was sealed May the 8th, 2019. He does appear to meet the criteria for UJR through the jail. Nothing in addition.
Thank you. Mr. Nixon?
Yes, Your Honor. This incident occurred on June 28, 2025. The officer was dispatched to 3351 Desert Circle, East Point. And upon arrival, the officer met with the victim, Ebony Smith, who advised she got into a verbal argument that turned physical with her girlfriend, the defendant. Smith advised that the two were at a friend's house in Lakewood when she got tired and fell asleep. Now, Smith advised while she was asleep, the defendant went through her phone and found messages of her texting other women. Smith advised that then they got when they got to the previously mentioned address, the defendant confronted her about the messages and slapped her with an open hand a few times in her face. And Smith advised the defendant then punched her in the lip with the closed fist. Now, the officer observed Smith with bleeding cuts on her neck and lower lip, as well as bloodstains on the shirt. Smith advised that she has been dating the defendant for the past 6 years and that she has previously stayed with the defendant in other apartments and has currently been staying with her at the previously mentioned address for approximately 4 days. Officer then spoke to the defendant, who advised that she and Smith got into it while walking home from McDonald's, and the defendant advised that Smith threatened to beat her up if she didn't send her $150. The defendant also remembered that Smith had her key ring. The defendant advised that she went outside to get her key ring and Smith would not let her have it. And the defendant stated that the officer, Thomas, arrived on the scene and advised Smith to let go of the keys, and Smith complied. Officer asked the defendant about the lacerations on Smith, and the defendant advised that Smith could have possibly just fallen down the steps. Now, officer has been able to speak with the victim. The victim stated that she and the defendant are no longer in a relationship. They no longer live together. Victim confirmed the events in the warrant and stated that this is the first time the defendant has been violent towards her. The victim stated that she has left the residence and does not plan to return, and stated that she is not in fear of the defendant and wants to continue contact. Per the facts in this case and the criminal history you've heard, Your Honor, the state's going to recommend a $500 surety for the battery family violence, another $500 surety for the battery family violence, and $500 surety for the simple battery family violence. No further contact with the victim to promote a cooling off period, to stay away from 3351 Desert Circle in East Point, no alcohol, drugs, or weapons while out on bond, as well as FVIP. And the state would ask for the court to sound for the victim when appropriate.
Ms. Ebony Smith, I believe I see you on the line. If you would like to address the court, now is your opportunity to do so. I will need for you to unmute yourself, and I'll have to swear you in. Ms. Smith, if that's you, Ebony Smith, is
Hello?
that you?
Yes.
Ma'am. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. What would you like to tell the court?
Oh, no, I don't have anything to say. It's yeah.
Okay, well, thank you for being here this afternoon. Mr. Bartels?
Yes, Your Honor. Thank you. I have spoken with Ms. Hall. She does deny the allegations that are in the warrant, but she did tell me that she and Ms. Smith are not living together, so a no further contact order would not be an issue. We would ask the court for a signature bond in this case. Her criminal history is very minimal. The last arrest was 6 years ago. And Ms. Hall is employed full time. She works at Allied Security. And I also advised that she was born in Atlanta, has lived in the metro area all of her life. And she has her mother and her aunt and her brother all live in the metro Atlanta area. So she's got ties to the community. I believe she would be an appropriate candidate for a signature bond.
Okay, for each of the battery charges, $1,000 signature bond through pretrial level 1 with a simple battery of $500 signature bond through pretrial level 1 makes for a total of a $2,500 signature bond through pretrial level 1. No further contact with Ms. Smith, no drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Hall.
Thank you, Your Honor.
You're welcome.
Next, we have position. I'm sorry. Go ahead, Courtroom.
Next is position 8, Mr. Dodson.
Okay. Good afternoon, Mr. Dodson. You have been charged in case 25 CR 003655C with 2 counts of willful obstruction of law enforcement officers and loitering and prowling. Is there a history, Ms. Jackson?
Yes, there are 11 cycles. The last arrest was October the 7th, 2024 in Fulton County for entering an automobile and possession of tools for commission of a crime, and theft by taking, and loitering or prowling, and criminal trespassing. That case appears to be still pending, Your Honor. That case number is 24 PI 007419. Also, appears to be an open probation case in DeKalb County for aggravated assault and exploiting/inflict pain to deprive essential services to a disabled person, an elderly person. That disposition date was February the 7th, 2018, and the term is for 10 years. And there's one prior, I apologize. There's a prior misdemeanor conviction that was in 2021 out of Douglas County for simple battery. He does appear to meet the criteria for UJR level 3. Nothing in addition, Your Honor.
Is this your case, Ms. Falk?
I'm sorry, for some reason I can't hear you. It's almost like there's a delay. So it may be on my end. This incident happened at Georgia Tech's campus. The specific address of the incident was, just pull up the right, was 845 Marietta Street Northwest in Atlanta. The defendant was seen on video camera pulling on door handles and entering into one of the vehicles on campus. They received a call from the campus motor transportation in reference to the defendant. Officers canvassed the area, then reviewed the video footage, identified Eric Dodson as the individual. The owners of both of the vehicles that the defendant was seen pulling and entering into reported to the scene. They verified that no damage had happened to their vehicles, no property was taken from the vehicles. The defendant was then located on Marietta Street and Mean Street. He was detained. He tried to run from the officers, but was unsuccessful, and he was placed under arrest. The previous case, Your Honor, the 24 PI 007419 case, the defendant has a $4,500 surety bond on that case. He is to stay away from 742 Meldrum Street, Atlanta, no weapons without a valid, and no drugs without a valid prescription. And again, that case was one where the defendant was charged with entering auto and theft by taking, as well as criminal trespass. On this case, Your Honor, the current bond on the defendant is a $15,000 surety bond, $5,000 on each count. There was a fourth count for criminal trespass, but being that the individual whose car he entered was not identified, the state did NOD that charge, so it went from $20,000 to $15,000 surety bond. I believe that's probably the magistrate court probably issued that bond in recognition of the fact that he was currently on bond for an entering auto and a criminal trespass as well. The state's recommendation is to stay away from the Georgia Tech property in its entirety and no alcohol, drugs, or weapons as well. We do ask the defense, we don't have any witnesses to sound for, and that's all for the state.
Okay, Ms. Tucker?
Yes, Your Honor. Mr. Dotson is a 33-year-old Atlanta native. He was able to provide me with a consistent mailing address. However, he is currently homeless. He has completed his high school education, but he is not currently employed. We are requesting a social worker visit for him, and we are also requesting a $1,000 surety bond for each count on his behalf. If a signature bond is not appropriate at this time, due to his homelessness as well as currently being unemployed, he will not be able to bond out on a $15,000 surety bond. He has no objections to a stay away from the Georgia Tech property, specifically the incident location at 845 Marietta Street Northwest. So that is what we are requesting, a signature bond, if not $1,000 surety for each count.
Okay, for each count will be $1,000 good bond, makes for a total of a $3,000 good bond. Stay away from all Georgia Tech properties. A social worker visit to assess for BHET and for housing, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Dodson.
Next, we have position number 9, Miss Evans.
Good afternoon, Ms. Evans. You have been charged in case 25 CR 003651B with battery, family violence, and simple battery. Is there a history, Ms. Jackson?
Yes, Your Honor. There is one prior cycle. The last arrest was September the 13th, 2020 in Fulton County for a fray. And that case was null pros on May the 12th, 2022. She does appear to meet the criteria for a UJR level 1. Nothing in addition.
Thank you, Ms. Falk.
Yes, Your Honor. This happened June 28th, 2025 at 4060 Herschel Road in College Park. Miss LaQuisha Evans is the sister of the defendant. The two of them got into an argument over $20 that the defendant believed that Miss LaQuisha Evans owed her, and then the defendant punched her. The defendant actually admitted to punching LaQuisha Evans first out of frustration. That then led to a physical fight between the two, with Miss LaQuisha Evans defending herself against the defendant initiating violence against her. Miss LaQuisha Evans suffered some visible scratches to her chest and back due to this incident, and the defendant was arrested. We are requesting an SOB through pretrial services based on the lack of history, no further contact with LaQuisha Evans, stay away from 4060 Herschel Road in College Park, no alcohol, drugs, or weapons, in 2 days, anger management or anger awareness. We would like to sound at this time for Miss LaQuisha Evans. That's all for the state.
Ms. LaQuisha Evans is on the line and wishes to address the court. Now is your opportunity to do so. Okay, Ms. Tucker.
Yes, Your Honor. Miss Evans is a 22-year-old Atlanta native. She's completed 11th grade education. She's currently self-employed as a hairstylist, and she is the primary caregiver to a 4-year-old child. The incident location, we are going to object to the state's recommendation to a stay away. The incident location is her residence. More specifically, is her mother's residence. However, Miss Evans, um, her name is on the lease as well. And we are going to ask for no violent contact between the two sisters. There's been no other incident where police have had to be involved, and because they are relatives, and I do believe they both reside with the mother, we are asking that they be allowed to have no violent contact in the future. But given that Miss Evans is 22 years of age, her history consists of one charge from when she was a juvenile at 17 years of age in 2020. We don't want this case to result in her being homeless, with ordering us stay away from her mother's residence.
And Your Honor, I agree. Has the PD's office talked to Miss LaQuisha Evans? Is she fine with no further violent contact? Because the state has no additional information with which to offer anything but no further contact unless the PD's office has something to the contrary.
I haven't had the opportunity to speak with her sister regarding this. I've only had the opportunity to speak with my client.
See LaQuisha Banks on the line. I'm not sure if that's the same as LaQuisha Evans, but if it is, your
It
testimony.
is not, Your Honor. That's
not.
the victim in another case.
Okay, thank you, Ms. Falk. So Ms. Tucker, without speaking with Ms. LaQuisha Evans, then I'm happy to modify it at some other time when we've had an opportunity to speak with her. But at the present time, I will give her a signature bond for the battery, a $2,000 signature bond through pretrial level 1 for the simple battery, $1,000 signature bond through pretrial level 1, 1-day anger awareness. No further contact with Ms. Evans at this time. If Ms. LaQuisha Evans is staying at the Herschel Road address, at this time, Ms. Tayisha Evans obviously can't stay there, so I'll give her a one-time escort. If Ms. LaQuisha Evans is not there, she can stay. If she is there, she's going to have to gather her belongings and find somewhere else to stay until the bond is modified, if and when that happens. No drugs, alcohol, weapons while out on bond. Good luck to you, ma'am.
Next is position 4, Mr. Campbell.
Okay, and Mr. Campbell, is this going to be a plea?
Yes, sir.
Yes, Your Honor.
Okay. Good afternoon again, Mr. Campbell. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can place your hand down, Mr. Campbell. Ms. Falk?
Yes, Your Honor. You've already heard the facts of this case. The state's recommendation is 12 months probation, balance of 4 days, credit for time served, 2 days from June 28th to June 30th of 2025. Balance suspended. Stay away from the Georgia World Congress Center at 20 Andrew Young International Boulevard. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Ms. Tucker?
Yes, Your Honor, we do stipulate to a factual basis.
Anything further?
Nothing from the
Not
state,
at
Your
this
Honor.
time.
Okay, I do have the plea paperwork that I'm signing, and we'll get to Ms. Bridgewater as soon as I take the plea. Let's see, Mr. Campbell, it's my understanding that in case 25 CR 003646B, you wish to plead guilty to criminal trespass. Is that correct?
No.
Say it again.
I swear to no, sir.
Okay, is this a no, has a no been agreed upon? I'm sorry.
No, Your Honor, the state didn't agree to a no law on this.
My apologies. Did you want to consult about that, Mr. Campbell?
I beg your pardon.
I'm sorry.
I beg your pardon.
Oh, you can't hear me. Did you want to consult about that? Do you want to enter a guilty plea? The state has not agreed to accept a no plea.
Yes, ma'am.
Yes,
So
you
the-
want to speak about it, or yes, you want to enter a guilty plea.
I'm entering a guilty plea. Enter a guilty plea.
Okay, and just for the record, the court would not have accepted a no plea, given that he's pled no, it's my understanding, to criminal trespass and at one prior time. So again, Mr. Campbell, it's my understanding that you wish to plead guilty to this criminal trespass charge. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by Ms. Tucker. Are you satisfied with what she's done for you?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Say it again.
Has anybody forced you or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Mr. Campbell, good luck to you, sir.
What I do next?
Well, if you don't have anything holding you, Mr. Tucker, you'll be released within the next 24 hours.
I will.
If you don't have anything holding you. And Ms. Bridgewater, let's see, let me go ahead and send you this paperwork.
I believe Miss Bridgewater was CC'd on it.
I have it.
Well,
I
Your
have
Honor
it.
needs to
Just
sign
waiting
it
for the
as
judge
well, I
to
guess.
sign it with all the other paperwork.
Okay.
Okay.
And is your honor in receipt of the no pros paperwork I sent for those two cases? I just want to make sure that got through to you.
If you sent it to my Fulton County address, I did not receive it. But if you sent it to my business address, I did, Mr. Sirocco. If you have that other address and want it, well, why don't you just send it all to Ms. Bridgewater and she'll get it
That
to
would be
me.
best.
Sounds good, Judge.
Okay, thank you.
I apologize, Your Honor. I did not hear the bond from Mr. Campbell.
There was a plea,
Mr.
Ms. Jackson.
Okay.
Okay, who do we have next?
Position 26, Ms. Scott.
Good afternoon, Ms. Scott. You have been charged in case 25 CR 003660D with driving while your license was suspended or revoked, improper erratic lane change, and too fast for conditions. Is there a history? Ms. Jackson?
Yes. There are 4 cycles. The last arrest was August the 28th, 2022 out of Michigan for assault. That charge was dismissed on December the 20th, 2022. There are misdemeanor convictions, one in 2015 out of Michigan for retail fraud, one in 2011 out of Michigan for larceny. She does appear to meet the criteria for UJR at level 1, nothing in addition.
Excuse me, Your Honor, she's Ms. Scott, Brittany Scott said that is not her.
Do you have a different history, Mr. Sirocco?
I do, Judge. I don't have that. Hang on. I'll tell you what I do have. I have failure to maintain lane, 2019 NOLO, failure to maintain insurance, 2019 NOLO, failure to maintain insurance, 2021 NOLO, and a 2018 FTA failed to appear for trial.
Okay, thank you.
This incident took place July 17th, 2023. So this is a delayed arrest here at around 1 a.m., nearly 1 a.m. on Old National Highway in College Park. The defendant was traveling north on Old National Highway when she struck the rear of a vehicle driven by a Mr. Robert Jones. According to witness Anthony Davis, the defendant was traveling at a high rate of speed when she saw a person crossing the street, proceeded to swerve to miss the pedestrian, and that the defendant's vehicle began to fishtail, which is when she struck Jones's vehicle. And after striking Mr. Jones's vehicle, that the defendant's vehicle flipped several times. It was discovered that her license was suspended at the time of the incident. Warrants were issued for her arrest. State's recommendation here is a signature bond through pretrial services, no driving without the proper documentation, including valid license, insurance, registration, and no drugs, weapons, or alcohol while out on bond.
Mr. McLean, if it's agreeable with you, it will be a $500 signature bond for each charge, making for a total of a $1,500 signature bond through the jail. No driving without proper documentation, and no drugs, alcohol, weapons while out on bond. Does that suit you?
It does. Thank you.
Yes. Good luck to you, Ms. Scott.
Could I get that bond amount again, please, Your Honor?
Yes, $500 signature bond through the jail on each charge makes for a total of a $1,500 signature bond through the jail.
Thank you.
You're welcome. All right, see you next time. We appreciate it, Officer Milton. Who do we have in courtroom 2?
Position 22, Mr. McBride.
Okay, good afternoon, Mr. McBride. You have been charged in case 25 CR 003653B with 4 counts of willful obstruction of law enforcement officers and fare evasion. Is there a history, Ms. Jackson?
Yes, there are 2 cycles. The last arrest was November the 24th, 2016 in Fulton County for a failure to appear. And also there appears to be an outstanding hold out of Jonesboro, Georgia for stalking. The date on that warrant was July the 7th, 2022. And there's a misdemeanor conviction that was in 2016 for 2 counts of simple battery and criminal trespassing and obstruction of an officer. And does appear to meet the criteria for a UJR at level 1. Nothing in addition.
Thank you. Mr. Sirocco?
Yes, Judge, this incident took place June 28th, 2025 at 2420 Piedmont Road, Northeast Atlanta. That is the Lindbergh MARTA station. MARTA cameras caught the defendant fare evading by walking behind another person without paying the required fare. When approached by officers, the defendant refused to provide any sort of identification. And when officers attempted to detain the defendant, attempted to evade arrest by fleeing from said officers and tensing up the arms to avoid being handcuffed. There were 4 different officers involved in this arrest here. So hence the 4 different obstruction charges. As pretrial stated, there is a prior conviction for willful obstruction along with criminal trespass and 2 simple battery charges, one against an elderly or pregnant person. And you have that open case that is, as pretrial stated, from 2022, still open, still looking for this defendant. So a state's recommendation here is a $500 total surety, $100 on each count. Stay away from MARTA at Lindbergh Station, located at 2420 Piedmont Road, Northeast in Atlanta, and no drugs, weapons, or alcohol while out on bond.
Mr. McLean?
Your Honor, thank you. Vincent McBride is 34. He has a stable address. He gets his mail at 201 Washington Street, but stays at the Shepherd Inn. So he's not going to miss notice court and to keep up with court, just its notice. He graduated high school here in Georgia all his life. He's had jobs in 3 different restaurants in the last 5 years. Usually ask him about 5 years worth. And so he's worked as a cook in several restaurants and says he's pretty good at it. Your Honor, the fare evasion is $2.50, and the mathematics of the number of obstruction charges does have how many officers were present. I'm glad there weren't a dozen present. Your Honor, we would ask the court to consider a signature bond.
I'm going to release him to the hold. As such, it will be a $500 signature bond through pretrial level 1 for each charge, makes for a total of a $2,500 signature bond through pretrial level 1. Abide by any existing MARTA restrictions, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. McBride.
Next is position 1, and also Judge, we need a new announcement.
Okay, thank you. Good afternoon, gentlemen. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you do not have a private attorney, we're providing you with the assistance of a public defender this afternoon if you choose to utilize their service. Mr. Anderson, you have been charged in case 25 CR 003644G with simple battery family violence. Is there a history, Ms. Jackson?
Yes, Your Honor. There are 17 cycles. The last arrest was June the 8th, 2023 in Fulton County for terroristic threats and acts and possession of a firearm by a convicted felon, a felony first offender, and possession of marijuana less than an ounce. It does appear to be on probation for terroristic threats and acts. That case number is 23 SC 189464. That disposition date was February the 20th, 2024, and the term is for 4 years. It does appear to have an additional open probation case. That case number is 21 SC 177454 for aggravated assault. That disposition date was October the 26th, 2021, and the term is for 5 years and 6 months. And there are prior felony convictions, one in 2016 for theft by taking, one in 2007 for armed robbery and possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon in carrying a concealed weapon, a felony, and one in 2004 for fleeing or attempting to elude an officer, and theft by receiving stolen property. And he does appear to meet the criteria for UJR level 2. Nothing in addition, Your Honor.
Ms. Falk?
Yes, Your Honor. This incident happened back on September 11th, 2024 at 1385 Easton Street, Northwest in Atlanta. Officers spoke with Miss LaQuisha Banks and her children, of which there were 3, PA, KB, and KP. She stated the incident occurred when the defendant was hanging out in their backyard drinking. The defendant then entered the residence, began a verbal argument with Mrs. Banks over a cell phone, and Mrs. Banks stated that the defendant placed his hands around her neck. I wanted to point out a couple of things. The incident that happened, the conviction 23 SC 189464 also involved Miss LaQuisha Banks. In that case, it was a terroristic threat where the defendant threatened to kill her and shoot her. And there were also children present for that. There were actually 7 counts, 6 counts involving the children who were present. The defendant also had possession of a handgun by a convicted felon in that case. So not only was a threat made to shoot and kill her, but he was in possession of a firearm during those threats. One of the children that was present at that incident, PA, was also present at this incident as well. So this is the second time that a child has been exposed to this kind of violence between the defendant and Miss Banks. The first time being the 2023 case, which he entered a plea of guilty and received 5 serve 1, along with complete a family violence intervention program, no weapons, drugs, or alcohol, and no violent contact with Miss Banks and her children. The state is very concerned about the nature of the violence here. In fact, in the police report, it stated that the children were actually adamant that more had occurred. Ms. Banks then had the children go into a different room and did not allow officers to speak with the children further about what they had observed, which also is concerning for the state because not only are these children being exposed to it, but when the children are trying to talk to the police and tell them what they're seeing, they're being dissuaded from doing so. I do understand that this is kind of part and parcel of the cycles of domestic violence, but the state is concerned with this kind of repeated acts happening in front of the children and the children not being able to talk to law enforcement about what they're seeing in this home. We do ask, there was no bond set on this case, Your Honor. We do ask for a bond in the amount of $10,000, a surety bond, no further contact, FVIP if it hasn't already been completed, and stay away from 1385 Easton Street Northwest in Atlanta. No alcohol, drugs, or weapons, specifically no firearms. The defendant is also in custody on a possession of cocaine case with no, it may have a bond at this point, but it originally had no bond, 25 PI 005199. That also is concerning that the defendant was found with drugs on his person when he was arrested on this charge. We would like to sound from Ms. LaQuisha Banks. That's all for the state.
You have to unmute yourself, come on camera for me, and I'll need to swear you in. Yes, ma'am. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, Ms. Banks. You can place your hand down. What would you like to tell the court, ma'am?
First of all, I would like to address the court by saying I was not the person that called. This was a verbal altercation that was a disagreement. It wasn't violent or any such. And as I explained to the officer when he came, that it was nothing going on. I wasn't even aware of them being called. Prior to him being released, he has joined Divine House of Praise, a church that he has been going to faithfully. He has been also going to probation, willingly applying to all things. He has just signed up for anger management. So he has been applying. He's not a threat. I don't understand. And far as kids being exposed, this was a disagreement about a cell phone because a teen was being out of control.
Okay. Thank you for being here this afternoon, Ms.
No
Banks. Ms.
problem.
Falk, do you have any questions?
Yes. Ms. Banks, to your knowledge, has the defendant attended and completed family violence intervention program?
He just had the consultation. It's in his email. He received the email through from I can't think of the man's name, but it's in an email that was sent to his phone for him to start. They did the consultation already for him to start the program.
And do you know when he was released from that original case, the terroristic threats case?
No, I know next month will make a whole year that he has been out and he has been applying. He has been reporting to probation and everything. Anything that she asked, he has been going. He has been applying. There was a disagreement about a cell phone. So I'm unaware of this incident, to be honest, and I stated to the police officer when they came, but he has been applying to everything that they has been asked of him to do, even face-to-face face-to-face appearances with his probation officer. He has been in compliance with her and reporting every month.
And do you recall the children telling police on that day, September 11th, 2024, that the defendant assaulted you and pointed a knife at you?
And like I stated, there was no knife. He tried to kiss me and I turned my head and said, "No, reek," because he has been drinking. I did not want to smell that. He did not grab me of any form of hurt. And I also have the kids here with me right now.
Your Honor, nothing
PA.
further.
Okay, PA is
my
present.
apologies, Ms. Banks. I didn't mean to interrupt.
Oh, you good? Because PA is present. So I'm unsure. And the police officers walked off on themselves. They did not question. They asked for their ages and left. We stood in the door.
Thank you for
He
being
was
here,
not
Ms.
there.
Acton.
No problem, because Mr. Anderson was not there.
Thank you, ma'am.
You're welcome.
Yes, Ms. Tucker.
Mute me.
Yes, Your Honor. Mr. Anderson is a 40-year-old Atlanta native. He's completed an 8th grade education. As far as employment, he has been doing side gigs like completing yard work and working on engines whenever he can to make money. He does have children that he is helping to provide for. As far as the residents, the 1385 Easton Street Northwest, he's been residing there for the past year since he was released from being incarcerated. The incident date, as mentioned, was September 11th of 2024. There has been a substantial cooling off period and no further incidents have been reported. Due to this, we are requesting that he be allowed to return to his residence upon release. And we are asking for no further violent contact with Ms. Banks. We are also requesting a signature bond for him today. He has no prior failure to appears on his record. He's an Atlanta native. He has ties to the community. He works in the community. His children are here. And if a signature bond is not appropriate in this matter, we are requesting a $1,000 surety bond on his behalf.
Your Honor, I also wish to point out that on that 23SC case, one of the conditions of his probation was that he complete the Family Violence Intervention Program. It specifically says enroll within 45 days of release from custody. As you've heard, the defendant has been released for quite some time now and has not yet even started the FVIP program, which is why the state is asking for that as a condition of the bond.
Okay. It will be a $10,000 signature bond through pretrial level 2. He is to continue to engage in the FVIP program. If he is not currently enrolled in that program, he is to enroll in the program within the next 30 days. No further violent contact with Ms. Banks, no drugs, alcohol, weapons while out on bond. Good luck to you both.
Next is position 3, Mr. Brandon.
Good afternoon, Mr. Brannon. You have been charged in case 25 CR 003648G with 2 counts of simple battery family violence. Is there a history?
There are 2 cycles. The last arrest was February the 12th, 2012, in Valdosta, Georgia, for driving under the influence of alcohol. Does have 1 misdemeanor conviction that was in 2012. That charge was amended from driving under the influence to a non-fingerprintable offense in 2012. He does appear to meet the criteria for UJR level 1. Nothing in addition.
Thank you. Ms. Falk?
Yes, Your Honor. This happened June 29th of 2025 at 11 George Wythe Place Northwest in Atlanta. The defendant grabbed Miss Joyanne Fan by her legs and dragged her to the floor. Ms. Fan is married to the defendant and they do share children together. And the state would recommend a signature bond through pretrial services as the defendant has no relevant history other than a DUI from over 10 years ago. We did have an opportunity to speak with Ms. Fan, and she stated that they are married, live together at the location, they share 3 children. They got into an argument. The defendant grabbed her by her legs and dragged her to the floor. So she did confirm what was in the warrant. She said she got scared and called her mother-in-law. And then her mother-in-law, the defendant's mother, is the one that called the police. She stated he has never been violent with her in the past, and because of that, the state is recommending that SOB through pretrial services, no further violent contact with Ms. Fan, 2 days anger management, no alcohol, drugs, or weapons, and no firearms. That's all for the state. And we would like to sound for Ms. Fan if she is here.
Ms. Fan, if you would like to address the board, raise your hand for me. The other hand, please. You can put down your left hand. Just your right.
Okay, sorry. I got a signal cause I couldn't hear you completely.
Okay.
Yes,
Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
yes.
Okay, you can place your hand down. What would you like to tell the court?
So what happened yesterday afternoon was a one-time isolated incident. I don't fear him in any way, and we have 3 very young children, and I need his help raising them together. Thank you, Judge.
Thank you for being here this afternoon, ma'am. Yes, Ms. Tucker.
Yes, Your Honor, we have no objection to the state's recommendation of signature bond from pretrial services. Mr. Brandon is 45 years of age with only 2 cycles on his history, with the latest being over 13 years ago. So we are requesting a signature bond on his behalf as well. And we have no objections to no further violent contact with Ms. Fan.
Okay, for each charge will be a $2,000 signature bond through pretrial level 1, makes for a total of a $4,000 signature bond through pretrial level 1, 3 days of anger awareness, no further violent contact with Ms. Fan, no drugs, alcohol, weapons while out on bond. Good luck to you both.
Thank you, Judge.
You're welcome.
Next is position 11, Mr. Gilchrist.
Good afternoon, Mr. Gilchrist. You have been charged in case 25 CR 0036664F with 2 counts of battery and 1 count of simple battery. Is there a history, Ms. Jackson?
There are no prior arrests on file, Your Honor. He does appear to meet the criteria for UJ or to the jail. Nothing in addition.
Thank you. Mr. Nixon?
Yes, Your Honor. This incident occurred on June 29, 2025. Our officer was dispatched to 2331 Bolton Road, Northwest, in reference to a fight in progress. And upon arrival, the officer met and spoke with Ms. Princess Verian White. That's the victim, who stated that they were at a lounge when she came back from the bathroom. The defendant had quickly exited her messages, and she asked, but the victim, exited their messages. She asked why. Hold on. From the bathroom, yes, with the defendant, and who had quickly exited messages. She asked him why, due to previous incidents where she had been caught cheating. Ms. Verian White stated that they left the club, and on the way home, the defendant stopped the car in the middle of the road and slapped her glasses off of her face. The victim then stated that she reached for a pepper spray and sprayed him. However, due to the fact that she sprayed it in a small area, she was affected by it as well. So she stepped out of the vehicle due to her not being able to breathe. And then he drove off with her car. The victim called her brother, who was able to track her location due to her phone being left in the car, and it was pinging at the apartment complex of 1391 Collier Road. This is the said location that Officer Boykins, along with Officer Arrington, located the vehicle. The defendant, who was properly placed and searched after the officers went to that location. And after speaking with the victim, the officer met and spoke with Ms. Shalicia Cunningham, who stated that she saw the defendant strike the victim with an open hand in the vehicle. She stated that once the victim was able to get out of the car with the defendant, she placed the victim in her vehicle and then called 911. Now, the victim office has spoken with the victim. The victim stated that the victim and the defendant are in a relationship. They live together at 1391 Collier Road. They shared no children. The victim confirmed the events in the warrant and stated that nothing like this has ever happened before. stated that the defendant has never been violent towards her and stated that she is not in fear of the defendant and wants to continue contact. She wants the defendant to return to the residence, and I believe the victim may be on Zoom. Further criminal history and the facts of this case, Your Honor, the state's going to recommend an SOB through pretrial, no further contact. Currently, to promote a cooling off period to stay away from 1391 Collier Road, no alcohol, drugs, or weapons while out on bond, and a 3-day anger awareness. And the state would ask that the court sound for the victim when appropriate.
If Ms. Princess White is on the line and wishes to address the court, now is your opportunity. I need for you to activate your camera and unmute yourself if you choose to. Mr. Bartels?
Yes, thank you, Your Honor. I did speak with Mr. Gilchrist. He indicates that he's been in Georgia since 2010, that he is employed full-time. He's a truck driver. He works for General Wholesale Company, and also that he has family in the metro Atlanta area. His mother and his aunts all live here. So he does have ties to the community, has no criminal history. So we would ask for a signature bond. We would ask the court to consider no further violent contact based on what Ms. White has told the state. However, Mr. Gilchrist indicated he could stay somewhere else if the court would not be inclined to grant it. But we would just ask for.
Okay, for each charge will be $1,000 signature bond through pretrial level 1, makes for a total of a $3,000 signature bond through pretrial level 1, 1-day anger awareness, no further violent contact with Ms. White, no drugs, alcohol, weapons while out on bond. Good luck, Mr. Gilchrist. You're welcome.
Next is position 17, Mr. Haywood.
Good afternoon, Mr. Haywood. You have been charged in case 25 CR 003671C with theft by taking and willful obstruction of law enforcement officers. Is there a history, Ms. Jackson?
Yes, Your Honor. There are 7 cycles. The last arrest was June the 21st, 2025 in Fulton County for giving false information to an officer and burglary in the 2nd degree and obstruction of an officer. That case appeared to be still pending. That case number is 25 PI 005003. And he does appear to meet the criteria for a UJR level 2. Nothing in addition.
Thank you. Mr. Nixon?
Yes, Your Honor. This incident took place on June 29, 2025. The officer received a 911 call on a criminal trespass at the location of 508 Main Street in Atlanta. And the officer was advised by security that Lakevis Clark had noticed his iPad and bag was taken around the time the defendant was inside the parking garage. And Clark was able to track his iPad live and gave the officer instructions on where the iPad was located. The officer saw the defendant on the corner of Myrtle Street and 2nd Street. The officer proceeded to make contact with the defendant. Mr. Clark stated that he was going to ping a sound coming from his iPad. And as the officer was speaking with the individual, the sound from the iPad was coming from a green bag. And the officer attempted to detain the defendant, but he began to resist arrest and lawful orders. Officers conducted a search incident to arrest and discovered the stolen iPad and bag along with the firearm. And the Clark was able to describe the iPad along with a picture of him on the iPad. The bag was stolen, contained Clark's actual business cards as well, and the defendant was subsequently arrested. With regard to the 2025 charges and arrest of the given false name, date of birth, burglary, obstruction, the defendant did receive a $3,500 split bond on that charge. And per the facts of this case and the criminal history, as you've already heard, Your Honor, the state's going to recommend $1,000 surety for the obstruction and $1,500 surety for the theft by taking. No further contact with Lakevis Clark, no alcohol, drugs, or weapon while out on bond. Anti-theft course and to stay away from 508 Main Street Northeast in Atlanta. Nothing further.
Yes, Mr. Bartels.
Yes, thank you, Your Honor. I have spoken with Mr. Haywood. He indicates that he was born in Atlanta, has lived in Atlanta all of his life. Also, that he has a job, a full-time job as a furniture mover, and that he has family in the metro Atlanta area. His aunt and brother and grandmother all live here. So he has ties to the community. He does deny that he took this property with the intention of depriving the owner. He indicated that he was intending to make efforts to return it, but everything happened so quickly he didn't have time to do that. So I did discuss with him the issue of bond. He is wanting to ask the court for a signature bond if he qualifies. He indicated that he has an aunt who has cancer and that has taken a turn for the worse. And he did want the court to know that and take that into account. If the court's not inclined to grant a signature bond, we would just ask for a $500 bond on each charge and nothing further.
Okay, for each charge will be $1,000 signature bond through pretrial level 2. Makes for a total of a $2,000 signature bond through pretrial level 2. Anti-theft class, no drugs, alcohol, weapons while out on bond. Good
Thank
luck
you,
to you,
Judge.
sir. Welcome.
Next is position 18, Mr. Ingram.
Come on, man.
Good afternoon, Mr. Ingram. You have been charged in case 25 CR 003672G with simple battery, family violence, and obstructing or hindering persons making emergency telephone call. Is there a history, Ms. Jackson?
There are 3 cycles. The last arrest was February the 5th, 2016, with the City of Atlanta Police Department for driving while license suspended or revoked. There was no disposition for that arrest. He appears to meet the criteria for UJ or through the jail. Nothing in addition.
Thank you, Mr. Nixon.
Yes, Your Honor. This incident took place June 29th, 2025. The victim, Ms. Monty Mitchell, advised that she contacted the Atlanta Police Department to apartment, and that's MAA Gardens, I think apartment number 813, located at 1020 Lenox Park Boulevard, to monitor and be present with her as the defendant was moving out of the unit. She advised when law enforcement was contacted, the defendant got upset with her due to the police being called and began to drag her across the floor from the bedroom closet to the bed. While being dragged on the floor, the defendant took possession of Ms. Mitchell's phone to prevent her from calling the police any further. Ms. Mitchell advised that her and the defendant were together for over a year and have one child together. However, the child was not present on the scene. Our office has spoken with the victim. The victim and the defendant are in a relationship. They live together at the incident location and share one child. The victim confirmed the events in the warrant and stated that the defendant had damaged her closet. So she called the police to stop the defendant from further damaging her closet as he packed his belongings. Victim stated that nothing like this has ever happened before and stated that she is not in fear of the defendant, but only wants contact for their child. She stated that she does not wish to press charges, but does want the defendant to have a one-time law enforcement escort for him to retrieve his belongings. And I believe the victim may be on Zoom. Per the criminal history and the facts of this case, Your Honor, the state's going to recommend and request a SOB through pretrial. No further contact with the victim, no alcohol, drugs, or weapons while out on bond. A stay away from 1020 Lenox Park Boulevard, Atlanta. Anger awareness, and a one-time law enforcement escort to retrieve any items. And the state would ask that the court sound for the victim when appropriate.
If Ms. Mitchell is on the line and wishes to address the court, now is your opportunity. I need for you to come on camera for me. There you go. You can raise your right hand for me, please, ma'am. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. What would you like to tell the court, ma'am?
I want to tell the court that he's not a bad man. I don't want to raise my son in a broken home. We got into an argument and it got out of hand. I don't fear for my life. This is a man who took care of me during my pregnancy. We're with each other every single day. He made a mistake. I never wanted him arrested, but that was done against my will. It was out of my control, and that's what I want the court to know. I have a son, and he deserves to have his dad here.
Has this ever happened before?
No, it hasn't.
And you would like contact at the present time?
Yes, I do.
All right. Thank you for being here this afternoon, ma'am.
Thank you.
Mr. Bartels?
Yes, thank you, Your Honor. I have spoken with Mr. Ingram. As indicated, his criminal history is very minimal. We would concur with the state regarding a signature bond. I'm advised that he's lived in Atlanta all of his life. He has family in the metro Atlanta area, and he is employed full-time as a forklift driver for Americold. We would just also ask that the court consider no further violent contact, especially since they have a child together, and nothing further.
Okay. For the simple battery, it will be a $2,000 signature bond through pretrial level 1. For the obstructing or hindering a person making an emergency telephone call, $1,000 signature bond through pretrial level 1 makes for a total of a $3,000 signature bond through pretrial level 1. 2 days of anger awareness. I'd like for him to have a parenting class. No further violent contact with Ms. Mitchell. No drugs, alcohol, weapons while out on bond. Good luck
Thank
to you,
you.
Mr. Ingram. You're welcome, Mr. Bartels.
Next is position 20, Mr. Kane.
Good afternoon, Mr. Kane. You have been charged in case 25 CR 003674Y with simple battery. Is there a history?
There are 7 cycles. The last arrest was October the 24th, 2021 in Fulton County, for a charge associated with a CWAC and kidnapping and criminal trespassing. He does have misdemeanor convictions. Those charges on the last arrest were amended to 3 in 2022 for three counts of disorderly conduct. And there was one in 2013 for a non-fingerprintable offense. And he received a no low contendere sentence in 2003 for disorderly conduct. He appears to meet the criteria for UJR level 1. Nothing in addition.
Thank you, Mr. Nixon.
Yes, Your Honor, this incident occurred on June 28th, 2025. The victim, her name is Daisy Gibson, reported that the defendant hit her in the face and took her MARTA Breeze card. I've noted again the 2022 3 counts of disorderly conduct as well, and I think a warrant out of College Park for terroristic threats. Per the facts, per the criminal history, Your Honor, the state's going to request a $2,000 surety for the simple battery here, and no further contact with Daisy Gibson. Stay away from 680 Lee Street, Southwest Atlanta. The occurrence of this incident, no alcohol, drugs, or weapons while out of bond, as well as anger awareness, and stay able to ask that the court sound for the victim when appropriate.
If Ms. Daisy Gibson is on the line and wishes to address the court, now is your opportunity. Doesn't appear so. Mr. Bartels?
Yes, thank you, Your Honor. I have spoken with Mr. Kane. He denied that he was an aggressor or that this incident occurred the way it is in the warrant. The information in the warrant is pretty skeletal, but he indicated to me that Ms. Gibson had actually taken his card, and he attempted to try to hold on to his card, and she took it and then called the police. He indicates that he is employed at Delta Airlines in customer service, that's a full-time job. He indicates he's worked there for 18 years. He is wanting to ask for a signature bond. If the court is not inclined to do that, we would just ask for a $1,000 simple battery. And it looks like there's another charge of terroristic threats. That's another case. Is that correct?
I don't have any other charges. Who are you
Okay.
directing your question to, Mr. Bartels?
I guess it was if the court or the state could answer that. There's
It is a PI case, Mr. Bartels. It is not with our office.
case. Okay. All right. Thanks, Ms. Falk. Nothing further from defense, Your Honor.
Okay, it will be a $5,000 signature bond through pretrial level 1. No further contact with Ms. Gibson. Stay away from 680 Lee Street. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Kane.
Thank you, Your Honor.
Welcome.
Next is position 31, Mr. Williams.
Good afternoon, Mr. Williams. You've been charged in case 25 CR 003663B with hit and run. Is there a history, Ms. Jackson?
Your Honor, he does not have any prior arrests on file. He appears to meet the criteria for UJR and level, UJR through the jail, nothing in addition.
Thank you. Mr. Sirocco?
Thank you, Judge. This incident took place January 24th, 2025 at North Ave near Myrtle Street in Atlanta. Defendant rear-ended the victim's vehicle at a high rate of speed as the victim was waiting for a pedestrian to clear the crosswalk at the location. His name is William McPhillip. He was able to get a picture of the defendant's license plate, asked him to pull away from traffic so they could call the police and exchange info. The defendant ended up fleeing the scene. APD was contacted, information was relayed, and there was damage to Mr. McPhillip's vehicle as a result of the incident. Warrants were taken out here. State's recommendation is a signature bond through pretrial services, no drugs, weapons, or alcohol while out on bond. And we would stand for Mr. McPhillip if he happens to be on the line.
If Mr. McPhillip is with us and wishes to address the court, now is your opportunity. Mr. McLean, if okay with you, it will be a $5,000 signature bond through the jail, no drugs, alcohol, weapons while out on bond. Does that suit you?
Yes, Your Honor. Thank you.
Very good. Good luck to you, Mr. Williams.
Now, all we have is two waiver cases, positions 21 and 28.
Okay.
On Thompson, Your Honor, probably go forward, might go off of string on the
Okay, let's start with position 21, Chantel Marion, charged in case 25 CR 003631C with 3 counts of battery, family violence, 3 counts of simple battery, and cruelty to children in the 3rd degree. Is there a history, Ms. Jackson?
Your Honor, there are no prior arrests on file. She appears to meet the criteria for UJR through the jail, nothing in addition.
Thank you. Mr. Nixon?
Yes, Your Honor. This incident occurred on June 26, 2025. Officer spoke with Samantha Sams, who advised that her sister suffers from MH issues and was having an episode. The sister had threatened to, the defendant had threatened to kill her, and there was glass thrown on the floor. Officer returned to the location regarding a call that the sister of the defendant assaulted her and pulled her hair out. Officer Washington arrived at the location and attempted to make contact with the caller by knocking on the door. The defendant came to the glass screen door and advised the police were not needed. She locked the screen door and closed the main door, and shortly after the door closed, screams and the sound of tumbling were heard behind the door. Due to the exigent nature of the situation, the officer shattered the glass on the door, unlocked it, and made entry into the residence, and the defendant fell to the ground as officers entered the residence. Apparently, she had a metal shopping cart that she tossed onto the chair near her child. Our office was able to speak with the victim and advised the officer that shortly after, before we get into the victim aspect of it, Samantha, the victim, advised the officer that shortly after the officer left the location, the defendant became frantic and started moving random items. She grabbed her jacket and then she asked for it. She threw it on on at the bottom of the stairs. When she went to grab it, the defendant started to pull her hair and hit her with a closed fist at the back of her head. The defendant pulled out 3 locks of hair from her head, and she went into her room until officers came back. So getting into the speaking with the victim, officer speaking with the victim, victim stated the defendant has a history of inmate issues. She explained the defendant went to the Grady the day before this incident, but was released, and she said Grady should have never released her. The victim is not comfortable with the defendant returning to her home. And she is okay with no further violent contact, but the victim stated the defendant has a stepmother in South Carolina the defendant might be able to live with, or she would like the defendant to be admitted to a inmates facility. With regard to more information about that, victim stated the defendant was court mandated to take medication in South Carolina. Stated that when she moved to Georgia, she has not been taking the medication. Stated the defendant has been in Georgia for about 2 years. She stated that she does not want contact with the defendant and wants her to stay away from the residence, and will more likely need a one-time law enforcement escort to retrieve her belongings. Now, per the facts in this case, Your Honor, the state is going to recommend a $7,000 surety, a stay away from the incident location or for the violent contact with the victim, and a BHET to evaluate her for medical treatment. The state at this time would ask the court to sound for the victim in this case. Nothing further.
Ms. Champion, if you're with me, can we go off the YouTube, please?
Yes, sir.
Thank you.